Someone make it make sense.
Probably a couple.
Hello, hello. Welcome to another live stream for our second one so far, covering the Shanna Gardner case and Mario Fernandez Saldana. On the first live stream, we started from the very beginning of the docket and went through the preliminary court filings, and the last of which was the defendant's motion to disqualify the Fourth Judicial Circuit Office of the State Attorney, and it was enlightening to say the least. Shout out to Flash Fan, shout out to Candace. Love you guys. Thanks for being here and for joining us. There is some real problems with a huge breach of attorney-client privilege, and not just that, not just breaching it, but disseminating it to a large population of people in which they actually don't even know the extent of which, because the documents in the files it was exported, and then like emailed. And so basically they don't even really know who all has access to it. It could be pretty much anywhere. I was going to ask this same question. Candace is asking, what was your class about? I was going to ask that too. So thank you for beating me to it. So this is exactly where we left off last time, which is the state's response to the defendant. Now, at this point in time, remember, we haven't really seen anything from Jose Baez yet, because Mario was charged several months ahead of Shanna. And so sometimes I say Shauna or Shanna. I don't know which one it is. I think it's Shanna, but sometimes I say Shauna. I don't know. Anyway, but we will be getting into her involvement and Mr. Baez's involvement shortly, because like at this point, this document here, it was filed on 11/29. The defendant, as in Mario's motion that we covered on the last live stream, was from November 15th. Shanna was not even indicted until the end of August. So they were just getting their bearings, they had only just started getting involved. But after this, we will watch the hearing. It's the first hearing where the two of them appear together jointly, and they're there to argue about this. And it's going to be spicy for sure. And guess we will get to see Mr. Baez there as well. And so, yeah, a minister's development. Are you a minister? Is that a minister like as in church minister or some other type of minister? Okay, so let's go ahead and jump on into this, the state's response. I mean, and it's basically like, what are they going to have to say for themselves? Because how are you going to even argue that any of this was okay? We will find out. We will find out, people. All right, so introduction. Oh my God. You know what? This is exactly what I expected. And why is that there? Why is that justified to the left? Usually it's center. Anyway, they're coming out swinging, guys. They're coming out swinging. This is insane. This is insane. Okay, I don't even know. Wow. Okay. And so hold on. Let me back up. This is the first court filing in this case that I'm reading that has this is the first court filing in terms of just going in order, right, on the docket. That is of the state. So this is, how we get a tone for what we're dealing with when we read these motions. Now this is like holy shit, because this is how they're coming out, and now we can see what to expect from the state in this case. The defendant's motion improperly and without lawful grounds seeks to disqualify the prosecutor and the entire state attorney's office of the Fourth Judicial Circuit based upon a third-party vendor's inadvertent and brief oversight. Oh my God. I disagree with both of those. It was definitely not inadvertent, and it was definitely not brief, and it was not an oversight, and it wasn't even on behalf of the third-party vendor. It was on behalf of the prosecution. Anyway, in uploading a massive amount of data to an e-discovery platform without labeling the confidential communications. Well, at least they're admitting that. They are conceding a massive amount of data was uploaded to an e-discovery platform without labeling the confidential communications. The entire point of this platform was to find the confidential communications and make sure that no one sees them. Do you see how this is completely contradicts the whole purpose of it? The oversight, that's not the right way to, it's not an oversight, which involved uploading a few emails. It was 66, I think. 66 emails, guys. Wow. And one text between the defendant and his attorneys was an unintentional act by the third-party vendor. The prosecutor, once notified, observed the oversight quickly and, consistent with her ethical duties, contacted the defense teams to alert them to the oversight and immediately disabled the platform to ensure none of the emails or texts were viewed by anyone. Nope, that doesn't fix it, because you know what? As we saw they had an exhibit attached. We saw the exhibits in the last live stream. It was exported. So just in case, it's almost like just in case they take all this down, let's go ahead and export it so that it exists in the ether webs forever, right? No one from the prosecution team or the state attorney's office reviewed any privileged emails or texts. Well, there's no way that we can know that. Actually, sorry, we can know that because the defense quoted and showed emails where it was referenced by the prosecution, where they referred to things from the confidential privileged information. Oh my God. Courtesy, cooperation, integrity, fair play, and abiding by a sense of honor are paramount for preserving the integrity of the profession and to ensuring fair, efficient, and effective administration of justice for the public. Well, I agree with that, but the problem is y'all aren't doing any of that. The prosecution's actions in quickly correcting a third-party vendor's oversight and shutting down the platform, which prevented dissemination of the emails and the text, while alerting the parties involved, was consistent with the professionalism that all Florida attorneys should strive to attain. What are they going to say of the part about it being exported? Relevant factual history. I love how they're saying relevant, because in other words, this is like they're going to leave certain things out that they don't think are relevant. It should just be the factual history, you know? The state attorney search warrants for the cell phones and devices of Mario Saldana and Shanna Gardner. These two people filed a motion for a protective order to prevent the state from reviewing the search warrant returns on all devices based on invocation of marital privilege and attorney-client privilege. So basically, we went over that again on the last live stream, where because of the fact that though Shanna and Mario were like estranged, they were still technically married, so they have spousal privilege, right? And so there were two issues that were going on here. One was the marital privilege in terms of the communications, but the other was attorney-client privilege, right? A hearing was held before the Honorable Judge Charbula, different judge than who they have presiding now. The state was successful regarding the invocation of the marital privilege. The state and the defendants reached an agreement regarding the issue of attorney-client privilege. The state obtained an independent agent from the Secret Service, and they have it just labeled as agent, as to act as a taint agent for all the devices and downloads. I thought it was someone from the Department of, the Alcohol, Tobacco, and Firearms, like ATF. Anyway, all returned data was sent to the agent, who removed all attorney-client communications, which included emails and text messages. The agent used a list of provided names, phone numbers, and email addresses. The problem here, I already can see what they're saying. This is so stupid. This is just so stupid, because the whole point we covered last time was that Mario's attorney told him, label everything and put it in the title. It's confidential documents. Just put it there. And they were told, the state, they were all in agreement. They're to search for that keyword, confident, because then you know. Because again, there's things that go beyond just using the names and the email addresses and whatnot. You want to do that, like that was all included, right? We want to do the names, the email addresses, whatnot, but also search for this. And they didn't. During the investigation, the state only reviewed the detainted device data received from the agent. The state also obtained a Google search warrant for Saldana, which resulted in return of multiple folders for Google categories, one of which was titled emails. The state walled off the file titled emails in each return until the data could be sent to the taint agent. The emails obtained from the Google search warrant are still in the process of being reviewed by the taint agent. However, the other Google files are reviewed, which included photos, videos, and documents. Within one of the file folders, okay, well, here we're getting to the folder. Within one of the file folders from the Google search warrant for Saldana, there was a document titled Confidential Communications. Sorry, not confidential documents, confidential communications, which contained a spreadsheet with text messages between Henry Tenon and Saldana. Now, for anyone who's not familiar with this, Henry Tenon was the first person who was arrested and charged in this murder. And he took a plea deal very quickly. And we covered that in the last live stream. He was essentially their hitman, if you will, that they hired, allegedly. There were no attorney names, phone numbers, or emails listed on the spreadsheet. There were no attorney-client communications included in the file folder or document. So I think what they're trying to say here is that while this happened, the confidential communications thing, I think what they're saying is the stuff that was in there was not privileged information, and therefore it shouldn't qualify. The state utilized Nextpoint, a cloud-based e-discovery and document review platform, to create a portal where the data could be uploaded once it was detainted. Nextpoint sent a team to assist the state in uploading the discovery onto the platform. Nextpoint wanted to use, quote, an original source, quote, end quote, as much as possible for the uploading process, which means they would upload the data from its original source rather than a copy of the original source to preserve the metadata that is included in the original source. I think that's supposed to be one word, metadata. During the uploading process, Nextpoint inadvertently uploaded the original source of the search warrant returns for the Google data, as they'd been stored on the detective's computer, which were unredacted. And they uploaded the detained search warrant returns. The original Google search warrant returns for the emails folder that were downloaded to the detective's computer have not been viewed by anyone from the state or from law enforcement. Well, there's no way to know. The thing is this. We saw, again, it was attached to the exhibits. All people had access to it, and it included all law enforcement officers, included all the prosecutors. And that, right, in my view, that right there already is enough, because we can't know for sure whether they viewed it or not. It was disseminated to them, and it almost seems impossible to believe that they didn't view it, you know? So again, it's sort of like you can't, the appearance of impropriety is enough, right? We talked about that last time. In fact, the original search warrant returns for the emails folder remain zipped and compressed on the detective's computer. Additionally, the email folder is encrypted in such a way that even if opened, the contents of the folder cannot be viewed without running it through special software to view it. Otherwise, it would just be raw data. Regardless, neither the state nor law enforcement have viewed any attorney-client communications. This fact could have been easily discovered if anyone from the Tenon firm bothered to ask the state. Once the state became aware of the disclosure emails during the upload to the platform, the process was halted at approximately 4 terabytes of data, and all parties were prevented access to the platform. The state confirmed with the public defender's office that they did not view any of the attorney-client emails. In fact, the public defender's office has not even activated access to the Nextpoint platform. Now, the public defender's office is only involved as it pertains to Henry Tenon, because he's represented by public counsel. However, both Mario and Shanna have private counsel. So, uncivil laws here. What? Wait, what? Is that real? That can't be real. Or is that real? Kurt, are you here? I will fall over. I will literally fall over. I will fall over. Candace says this case is a mess. At this juncture, I would have to agree with you on that one. I don't. Hi, Kurt. I don't have any words for the fact that you're here, but thank you for being here. Please weigh in on things. I don't even know. What? Wow. Shout out to uncivil law is like an understatement, but I'm going to say it anyway. Flashfan has a question for later. If they are being tried together, but there is 2 separate cases, how would that work with a jury? Will they have 2 juries? What do you mean by 2 separate cases? Because 2 separate cases would be different. They couldn't be tried together if they have 2 separate cases. But I mean, as far as I know at this point, there's not, well, again, we're at the beginning stages, right? And I'm going in chronological order. We know, like, for example, with the Menendez brothers, they did have 2 juries, but so far I've not heard anything about, in this case, having 2 juries. But again, we're going in chronological order, so we might see motions for that later on. But having looked at the docket, I don't recall seeing anything yet about that. So, and I don't even know if in Florida, that would be a question for Peter Tragos. I don't even know if in Florida they even do that. I've not seen that happen before, at least with anything out of Florida. Kurt, feel free to weigh in as well if you're still here, because I don't even know. That's insane. Okay, so all right, so we covered the public defender's office because that's related to Henry Tenon. The state also confirmed with the Baez firm that although the data had been downloaded, only police reports had been viewed and no attorney-client emails had been viewed. Although it is the state's position, which is argued below in greater detail, that an evidentiary hearing is not necessary because Saldana has failed to carry his burden in establishing actual prejudice. I mean, again, I disagree with that, and thus has failed to demonstrate grounds to disqualify the prosecutor or the state attorney's office. Should this honorable court disagree, Nextpoint can testify. Can Nextpoint testify? I mean, can a disabled temporary e-discovery platform testify in court? How's that going to work? Are you going to get AI involved, get a robot? Testify about user downloads and reviews from the platform. Okay, so here's Saldana's allegations. In section 1 of the motion, the defendant alleges that the court must disqualify the assigned assistant state attorney from prosecuting. No. Oh, yeah. Wait, hold on. Okay, so let me just outline this. So in the previously covered filing from last time, right, in section 1, they start by saying the prosecuting attorney needs to be disqualified, right? That's the first step. And then part 2, right, was the entire office has been tainted. They all viewed it. The entire office needs to be disqualified. Okay, so they're addressing one by one. They're starting with the first allegation from section 1. from prosecuting the defendant where the assistant state attorney obtained attorney-client privilege information against the defendant and expressed intent to use such information against the defendant at trial. In support of the motion, the defense attorney cite Martinez, Reeves, and Nunez. In section 2 of the motion, wow, how quickly they got to section 2, the defendant alleges that the court must disqualify the entire state attorney's office from prosecuting the defendant, where the members of the state attorney's office disbursed attorney-client privilege information intended to use against the defendant at trial. In support of the motion, the defense attorneys cite Castro, Fitzpatrick, Martinez, Nunez, Popejoy, and or Reeves to support his request to disqualify the prosecutor and to disqualify the office of the state attorney. I mean, Saldana has the burden of proving the existence of an attorney-client privilege. Well, I feel like that burden was established easily. So, right, there's 2 defense teams. That's correct. Yeah. Right. There's 2 defense teams. Yeah. But that wouldn't necessitate 2 different juries, you know. They have the right to each have their own counsel. And remember, again, they were charged really separately from each other, right? I mean, Henry Tenon was first, and then it was a couple months later for Mario, and then it was like many months later for Shanna. We covered all that, I think, in the last live stream, the timeline of all that. Yeah. And again, another great example, I mean, even though, you know, again, RICO, but for anyone that was watching YSL, right, you know, there were 50 bazillion attorneys in that courtroom, you know, and because each defendant had their own team of attorneys. So in this case, it's even, you know, this is minor compared to that. So the case sub judice involved an unusual fact pattern because, oh, sorry, I just didn't mean to scroll. Hold on. Okay, there we go. All right, codified in statute 90.502, Florida statutes, and then it's going to quote here, quote, the attorney-client privilege is the oldest of the privileges for confidential communications known to common law. Yep. The privilege was developed to encourage, quote, full and frank communication between attorneys and their clients, and thereby promote broader public interest in the observance of law and the administration of justice. And as I said on the last one, right, guys, I think where we're headed here is a Sixth Amendment violation, constitutional violation, because as it was established, they didn't get into that last time in that first filing, but what was established, right, is like the reason why attorney-client privilege is so sacred is because if a client cannot trust that their privilege with their attorney will be confidential, then it can impede, what am I looking for here? Effective assistance of counsel. If even the appearance that the client cannot be frank and candid with their attorney for the out of fear that it will be disseminated, right, or their confidential information will be breached, then they can't be frank and candid with their attorney, and therefore then we're getting into the inability for effective assistance of counsel. Now we're getting into a Sixth Amendment violation, and that's where I see this going with this. So yeah. The case sub judice involved an unusual fact pattern because generally when the state downloads a suspect's phone or computer as part of a criminal investigation, there are no attorney-client communications on the devices because there has not been an arrest. And thus, an attorney has not yet been hired. However, Saldana, of note, obtained a lawyer before he was arrested, which allegedly resulted in attorney-client communications being on his phone and computer. Okay. Although the emails and the text at issue in the instant case occurred prior to charges being brought against Saldana, the state concedes Saldana has properly alleged an attorney-client relationship. However, establishing an attorney-client relationship does not necessarily mean that Saldana has established an attorney-client privilege regarding all the documents that he claims are privileged. All right, let's see how they're going to argue this. The policy behind the attorney-client privilege to promote freedom of consultation with the legal advisors being, end quote, exception to the general duty to disclose, end quote, and, quote, obstacle to the investigation of the truth, end quote, ought to be strictly confined with the narrowest possible limits consistent with the logic of the principle. Saldana has failed to prove every email at issue involved attorney-client privileged information. For example, the Google document that Dreiser alleges Saldana forwarded to his attorney that contained text between Saldana and Tenon is not a privileged document because no attorney was privy to the text at their creation. To the contrary, no attorney was privy to the text between Saldana and Tenon until they were transferred to an attorney, which was after they had been created and sent between Saldana and Tenon. The texts at issue are dated from approximately September 2021 through July 2022. Documents which are given by a client to an attorney while seeking legal advice are privileged in the hands of the attorney. And then this is italic, underlined, and bold. All three. Only if they are privileged in the hands of the client. Emphasis added. No kidding. No privilege having been accorded the emails between Saldana and Tenon when they were sent to each other, none can be conferred by merely transferring them to Saldana's attorney. Wherein the court held that the plaintiff cannot seriously contend that a document is protected by the attorney-client privilege simply because the plaintiff subsequently gave a copy of a non-privileged document to her attorney, as such does not convert the non-privileged document to a privileged document. I feel like there's going to be some argument on that, and we're going to hear it in the hearing very shortly. Hear it in the hearing. Oh, sweet. Okay, what is the uncivil law saying? Yeah, this can be a problem with people, right? And I was thinking P. Diddy. Who else was thinking P. Diddy with this, right? With that whole thing with the legal pads, that definitely could be a problem, right? For sure. I mean, they have a point there. So this is what we will see, right? What was the content of that information? Yeah, particularly in corporations who are sometimes under the mistaken impression that anytime, right. Yeah, no, that totally makes sense. The problem is like when the state's being weaselly, right? It's like it remains to be seen. Like, this is a good point. It does remain to be seen what that content was and was it actually privileged? And again, they're going to be arguing over it, but the state being weaselly about this so far there's been a lot of that, especially in the first beginning part. It came out swinging. Anyway, so we'll see what happens. But yes, that is a good point. It definitely can be abused. Again, the P. Diddy is a great example with the whole legal pads and all that, if you guys are familiar. So I see what you're saying. So I think you're talking about, though, like for the case in chief, the defense case in chief. Yeah, I would imagine when it gets to the defense case in chief, they would have to be separate, I would imagine. It's interesting because we just don't see this very often, like I still feel like at some point there's going to be a motion to sever, but we just haven't seen that yet. So yeah, we'll see. Saldana has the burden of proving prosecutorial misconduct in a motion to disqualify. The party bringing a motion to disqualify bears the burden of proving the grounds for disqualification. A defendant's motion to disqualify a prosecutor is properly denied when there was no benefit to the prosecution and no detriment to the defendant. And they're citing here a case where the defendant's motion to disqualify the prosecutor for listening to privileged calls was denied because it was clear the defendant knew the calls were being recorded and the calls did not provide any benefit to the prosecution and was not used to the detriment of the defendant. Of note, the cases cited by Saldana are factually distinguishable from the case subject as discussed below. Castro v. State. In Castro, the defendant's first defense attorney was subsequently hired by the state attorney's office to prosecute capital cases. The current prosecutor called Tati to discuss responses he could make to Castro's pending motions. Tati testified that he only discussed legal case law that he had uncovered in a different case. The trial court denied the motion to disqualify. The appellate court reversed the penalty phase and held that the integrity of the judicial process was brought into question because an attorney who previously represented a defendant cannot assist in the process. Well, that's a little bit different, right? That's a little bit different. I mean, there could be overlap there at this. I mean, here, what comes to mind for me, I'm thinking Adelson, right? I'm thinking with Charlie and Donna Adelson and with Daniel Rapp. I'm thinking, well, that's the first thing that came to mind there, right? Where we have this problem where they've got one attorney representing everybody in that matter. And that was a clear problem from the get-go. I don't know how it went along as far as it did on that, but anyway, but essentially, there's a couple of different issues there, right? So there could be an issue when it comes to privileged information, but in the case as it pertains to Adelson, right, there the problem was that that it would impede the ability for Donna, if anyone were to call Charlie to testify, right, and then being cross-examined by his previous or current counsel, but then also what happened was in the Charlie Adelson's appellate attorneys found that it actually had, he's going to end up with a new trial, right? Because essentially, because of the fact that Daniel Rashbaum was was representing Donna as well, they did not call her to testify at trial. And so the conflict of interests there are immense, basically. And then Nunez versus v. State. In Nunez, the technology director recorded and broadcast the confidential conversation between an attorney, or the attorney, and the defendant as they waited for a Zoom hearing to begin. The prosecutor acknowledged that he was in the courtroom during the broadcast, but claimed he was not really listening. Okay. Subsequently, the prosecutor indicated he was going to use the recording at trial. The district court held that although the entire state attorney's office could not be disqualified, the prosecutor could be. Well, at least here they're kind of conceding that if anyone's that the prosecutor could be disqualified potentially in this case, but I guess they're saying the whole office wouldn't. And then Popejoy v. State. In Popejoy, the defense attorney was hired by the state attorney's office. After being hired by the state, Popejoy's prior defense attorney was seated at the state's table during hearing. The court held that the law is unequivocal that an attorney cannot participate in the prosecution of a person he or she previously represented in a criminal case. Reeves v. State. In Reeves, the current prosecutor previously represented the defendant in a different criminal case. The court noted that the reversal would not be required if the prior lawyer had handled a perfunctory task such as a bond hearing. However, if the court cautioned the state attorney's office to properly screen the lawyer, however, the court cautioned the state attorney's office to properly screen the lawyer from other prosecutors. And then here we are, State v. Saldana. In the instant case, unlike in Castroy, Popejoy, or Reeves, the prosecutor did not previously represent Saldana. Additionally, and unlike in Nunez, the prosecutor can establish through forensic evidence that the emails and the texts were downloaded to the detective's computer as part of the search warrant return were never unzipped. So what they're saying is remember we talked about the 66 emails last time? They're saying that they can prove that they were not unzipped. What they haven't gotten to yet is the part about it being exported. So we'll see. Allowing an outside vendor to oversee the uploading of the data to the platform, which resulted in alleged privileged emails being uploaded and unlabeled, is not grounds for disqualification of the prosecutor. And then they're saying these are the holdings from this case here, wherein the court held that the disqualification is not a proper remedy for poor judgment. Therefore, the state submits that this honorable court should deny Saldana's motion to disqualify the prosecutor because he has failed to demonstrate prosecutorial misconduct, because he has failed to prove, this is kind of a run-on sentence, failed to prove that anyone from the prosecution team or law enforcement read the email. So what they're saying is they didn't, again, so earlier I was like, well, are they going to be able to prove that they didn't read them? And he's saying we can prove, they can prove it. They can prove they were not read. Saldana has the burden of proving actual prejudice. Okay, so Saldana has the burden of proving demonstrable and actual prejudice. The disqualification of government counsel is a drastic measure, and a court should hesitate to impose it cavalierly, even if imposed as a sanction, unless disqualification is necessary. A trial court cannot grant a motion to disqualify based on an appearance of impropriety to uphold the integrity, competence, and the independence of the third branch of the government. So, in the defense motion, they were saying the exact opposite, right? That the appearance of impropriety is a huge part, is an issue here, right? And that is grounds for the motion to be granted. Additionally, neither assumptions nor speculation will suffice. In the case sub judice, Saldana has failed to prove any actual prejudice. In his motion, Saldana alleges that the prosecutor indicated an intent to use confidential information at trial. Right. And I actually said that at the time on the last live stream. I was like, well, that's the one thing I said. I said, of all of the things that they were alleging, I was like, what I haven't seen yet is the part where they say they're going to use it at trial. And then I feel like I was like, Chelsea, keep reading. Because I feel like after that, they did show that intent. But anyway, I did comment on this at the time. I was like, well, we haven't seen that yet. However, the evidence the prosecutor referenced, although labeled by Saldana as confidential, was in fact not confidential as explained above. Okay, I see what they're saying here. So what happened last time, again, I said, oh, we haven't seen that they intend to use it yet. And then the part that happened was it was referencing this part about the confidential communication folder, right? So what's going to happen here is this goes back to what Kurt was saying too, right? That if the contents of that confidential communications folder is attorney-client privilege, then this makes then the defense is right, because they did say something about intending to use that. However, if that folder, if that's found to not be attorney-client privilege, then they could be correct in this, because that folder is what the state is intending to use, if that makes sense. Oh yeah, I totally heard that. Yep, I know. Val is going to represent herself. Yep, she surely is. She surely is. So the state is going to have to present this. My understanding is that the state will have to present their case against both. That's my understanding. At the same time. And that's what I was saying. I was like, that's going to be, luckily in Florida, the jury can take notes. Typically, most jurisdictions and most judges will allow that. I think that will be really necessary, but they're going to have to make their case. My understanding is that they will make their case against both, and then they will each have a chance to present their own defense. Okay. Right. So the folder, right? Or the confidential communications folder. So additionally, as discussed above, the prosecutor has not reviewed the emails or texts at issue. Yeah. So they're saying that the stuff that they did have access to, they didn't review it and they can prove it. And then the other stuff that they said they have access to, reviewed, and will use at trial doesn't count as attorney-client privilege. So this is what they're saying. No actual prejudice results when the evidence at issue is not used at trial. Yeah. I mean, that makes sense, right? That does make sense. It's just a matter of, is it privilege or not? And then they're citing this case law. Okay, let's see here. Because the prosecutor has not reviewed the emails or texts at issue and has no intention of using them at trial, Saldana's motion should be denied in its entirety. And then here we have disqualification of the entire office would violate the separation of powers doctrine. Saldana also wants this honorable court to disqualify the entire state attorney's office because the prosecutor allegedly provided prejudicial information related to the pending criminal charges. In support of his allegation that this honorable court should disqualify the entire office of the state attorney, the defense cites Fitzpatrick and Martinez. However, as discussed below, these cases do not support a disqualification of the entire office. Now they're going to outline these cases. So State v. Fitzpatrick. In Fitzpatrick, the defendant spoke with the defense attorney while in jail but did not hire him. Subsequently, the defense attorney became a prosecutor. The Florida Supreme Court held that the imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the disqualified attorney did not provide prejudicial information relating to the pending criminal charge and did not personally assist. I mean, yeah, well, that makes sense because it says he didn't even assist in the prosecution. In the case sub judice, Saldana has failed to demonstrate that the prosecutor either personally reviewed prejudicial information or that. So this is going to be another element to this that we're going to get to at this hearing, right? They're going to have to try to show that this information was reviewed. Two things: that A, information was reviewed, and that B, the information reviewed was attorney-client privilege, and that C, they intend to use it at trial. So there's three factors. Let me review it again. So there's three things that need to be met here. One, the information was privileged, attorney-client privilege. B, it was reviewed and all that, right? And C, intended to use at trial. So keep that in our minds. Personally reviewed prejudicial information, right? The prosecutor reviewed prejudicial information or anyone else in the state attorney's office. And then in State v. Martinez, the prosecutor listened to 2 jail calls. Yeah, this one, with the jail calls, I was like, I don't know if that's on point. The trial court disqualified the state attorney's office and the state filed a petition for a writ of certiorari. The appellate court dismissed the writ and held that it would not be sufficient to simply. And I will say that, again, just scrolling through the docket, there is a writ in our near future here with this case. The appellate court dismissed the writ and held that it would not be sufficient to simply disqualify the prosecutor involved because the calls had been discussed with others throughout the office. Again, in the case sub judice, Saldana has failed to demonstrate that the prosecutor either personally reviewed prejudicial information or that the prosecutor provided prejudicial information to anyone else in the state attorney's office. Furthermore, as held in Martinez, such information would not be sufficient to disqualify either the prosecutor or the entire state attorney's office. Regardless, an entire office, which is what the defendant is requesting, cannot be disqualified because one member of the office may have a disqualifying interest. And then we have no prejudicial information was provided to others. Okay, what about the exporting part, though? I can't wait to see what happens with this. In his motion, Saldana claims that the disclosure of the privileged information in the instant case is more severe because at least 25 individuals, including co-defendant Tenon, obtained the emails. However, as discussed above, computer forensic evidence demonstrates that no one accessed the emails or the text issue. I'll say it one last time. Again, this is where the exporting comes in. Because if they're saying they weren't accessed and they can show that no one accessed it through the database, it being exported, right, and distributed, then that's a whole separate thing. Imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the prosecutor did not provide prejudicial information relating to the case because a state attorney's office is not like a law firm. Instead, an appellate court cannot uphold an entire state attorney's office being forced by an entirely separate branch of the state government to recuse itself from exercising its constitutional prerogative to prosecute a criminal matter in a county unless actual prejudice is shown. Thus, disqualification of the state attorney's office is proper only if specific prejudice can be demonstrated. And then Saldana failed to demonstrate actual prejudice sufficient to disqualify the entire office. Actual prejudice is something more than mere appearance of impropriety. So this is when they're going to argue about this because they're going to argue about this. Therefore, disqualification of a state attorney's office is appropriate only to prevent the accused from suffering prejudice he otherwise would not have. In Farina, the prosecutor asked the clerk's office to assign a case to another division so that he could obtain a specific judge, which the clerk agreed to do even though the request was contrary to an administrative order controlling the assignment of cases. Why does that ring a bell for something? I don't know. That rings a bell for something. Maybe I'm familiar with that case. The Florida Supreme Court noted that although they did not condone the prosecutor's actions, the trial court did not abuse its discretion in declining to disqualify the entire state attorney's office because the judge ultimately did not try the case, and thus there was no actual prejudice. Under Florida's Constitution, the decision to charge and prosecute is an executive responsibility, and the state attorney has complete discretion in deciding whether and how to prosecute a case. The core of prosecutorial discretion is the decision whether to charge an individual with a criminal offense in the first place. The Supreme Court has repeatedly reaffirmed the principle, which dates back to centuries, it says, that the executive branch has executive authority and absolute discretion to decide whether to prosecute a case. Courts have imposed a substantial burden on defendants seeking the recusal or disqualification of entire office of prosecutors because of serious separation of powers implications and broad concerns about the effective administration of justice. The 10th Circuit Court held that it can only rarely, if ever, imagine a scenario in which a district court could properly disqualify an entire prosecutor's office, and such disqualification is almost always reversible error, okay? If the disqualification of one government attorney could serve as the predicate for the disqualification of the entire office, the administration of justice would be irreparably damaged. So one thing I'm getting so far, and we're almost at the end of this this document here, one thing that I'm getting is that it seems kind of like the state here is almost conceding, like they have way more supporting case law as it pertains to disqualifying the entire office. But as I pointed out earlier, it almost seems like they're conceding that the prosecuting attorney could be disqualified from what we've seen so far. Screening procedures such as recusal of the affected attorney and building a wall between the affected attorney and the rest of the office is sufficient. Again, so even here, they're conceding if we can build a wall between the affected attorney and the rest of the office, then that matters, right? But again, that would almost say, like in this case, we can disqualify the prosecutor, but the rest of the office is safe. It's sufficient to remedy any conflict of interest one attorney in the office might have. Thus, because disqualification of the entire office would violate separation of powers, this honorable court should deny Saldana's motion to disqualify the entire state attorney's office. Remedies. All right. And I actually asked this question last time. I was like, what are the remedies? I literally said that. I was like, how are they going to remedy this? A remedy is only necessary if this honorable court finds that there was actual prejudice in the state's brief and unlabeled disclosure of the emails and text on them. So this gets back to the three questions that I just outlined with A, B, and C of what is going to matter here, right? However, the state's position is that a remedy is unwarranted because the state rebutted Saldana's claim of actual prejudice. Regardless, the only two remedies Saldana has offered this honorable court are disqualify the prosecutor and disqualify the entire office of the state attorney. Disqualification of, okay, now they're back to this one. Disqualification of the prosecutor is an improper remedy because no one from the prosecution team, law enforcement, or co-defendants access the emails or text at issue. Furthermore, disqualification of an entire state attorney's office should be rare and will usually result in a reversible error because the disqualification of a prosecutor should not be. So I think at this juncture, they're kind of making the case for the part about the entire office, but I don't know about the prosecutor. I think that still remains to be seen. Because the state does not know what the emails or text contain. And again, that's going to, well, sorry, not that, but then when it comes to the folder, right, the confidential folder, that's the thing that's going to matter, what the content is. And because speculation is an insufficient basis to grant relief, as an alternative to the remedies requested by Saldana, the state proposes that this honorable court could review the emails and text issue in camera. Yes, there we go. Remember when I was like, we need to know what it is? Well, we're not going to learn, especially if it's privileged, right? But this is sufficient, right? This is correct. Should be reviewed in camera because they have to determine whether they contain privileged attorney-client communications. That's really the heart of this. Is it privileged or is it not privileged? What is it? What is in those the Google and the emails and whatnot? In this court, if this court determines that the emails and texts do not contain privileged communications, a viable alternative remedy would be to suppress the state's, if they determine that they do contain it, right? A viable alternative remedy would be to suppress the state's use of the emails or text trial. Okay, I agree. Of note, the state has already prohibited access to the emails and text issued from the discovery platform. Additionally, this honorable court could hold a hearing wherein the state can use computer forensics to demonstrate that the emails and the texts were not reviewed by, so they weren't reviewed. So again, that's the other thing, because they have to have, it has to have privileged information. It has to have been reviewed. So these are the different things that they're outlining again here, which will rebut Saldana's allegation of actual prejudice. Again, they have not addressed the part that the defense alleged about it being exported. They've not addressed that. They've just completely ignored it. Conclusion. Saldana's motion is based upon an incorrect assertion that the prosecution team, law enforcement, or co-defendants accessed emails and a text that contained attorney-client communications. Disregarding the incorrect assertion and the fact that the motion is based on speculation, This honorable court is confronted with a single inquiry, whether Saldana has proven sufficient facts to justify the disqualification of the prosecutor and the extraordinary action of ordering the disqualification of the entire state attorney's office of the Fourth Judicial Circuit. For the reasons argued above, the answer to that inquiry is a resounding no. A resounding no, because the breach in the upload process was quickly identified and immediately neutralized. Again, as they mentioned at the very beginning, they're like, we can have Nextpoint testify? Like, how are you going to do that? Thus, not only has Dreiser failed to prove sufficient facts to justify disqualifying the entire state attorney's office, but he's also failed to prove sufficient facts to justify disqualifying the prosecutor. Furthermore, if a breach of privileged information occurred, Dreiser has failed to demonstrate that other remedial measures would not be appropriate. Wherefore, the state respectfully requests that this honorable court deny Saldana's motion to disqualify in its entirety. The state also prays that the defense will in the future ask the state simple questions. Came in swinging, leaving swinging. That the defense will in the future, hold on. Will in the future ask the state simple questions rather than filing spurious motions. Oof. And wow, look at that. That is special. So this is Mr. Mizrahi. We're going to meet him very soon. Dude, Uncivil, thank you for being here. And please feel free to join the Discord. And I thought we'll put a link in the chat. I'm still flabbergasted that you're here. I will never get over that. I love your channel, and I love, oh my God, I just blanked on her name. The bee fish, Callie the bee fish. Love that, by the way. I just have to say that, every time you did the Callie the bee fish, I love, that was my favorite thing. And we haven't seen her in a while. So, but you know what? Yeah, that's awesome. That's super cool. Glad you were here. So now it is time for the hearing, guys. So let me pull that up. I have it queued up here. So I just need to unshare, reshare as per usual. Here we go. Coolio. At IT.
On behalf of the state, number 5 on court's calendar, Mario Fernandez Saldana, and number 6, Shanna Gardner.
Here we go. By the way, y'all will see that Mr. Baez
for Ms. Gardner
has not changed a day. Yeah.
Mr. President, Mr. Baez and Mr. Sullivan are on Zoom listening there.
Good morning. Good morning. Wait a minute.
Looks like a guy from Field Dog.
All right. Officer, sir, turn your camera on, please. Officer.
So let me just address a couple questions here. If you mean sequester the jury in terms of the entire trial process, that is so rare. I mean, it really is. They did it in Delphi, and they did it for Casey Anthony. But in Florida, I feel like we've not seen that in a long time. I don't know that they will sequester the entire jury. I mean, this case is not as high profile as other cases. So, and then as far as this part, I don't know how people compare. How are people saying it's similar to Koberger? If you can let me know, then I can answer that question.
All right. Okay. Where's Mr. Baez?
Mr. Baez is in a place where he's not able to. He's listening, Your Honor.
Oh, he's on Zoom.
Sorry about that, Judge.
Oh,
I will be speaking the least today, so.
Yay! So he's on Zoom, but you can hear him. Yay!
There's a gentleman from Fields.
Freaking love him.
That didn't work. You okay?
No, it's not me.
All right. On my desk, there's a defendant's motion to schedule evidentiary hearing memorandum of law.
Yes, Judge.
Obviously, it just got placed here, so I haven't read it. I was trying to read it quickly. You want to give me just a moment?
Yes, Judge. That's fine.
Okay.
And that is the document that we will be covering next, because essentially, as I'm going again in a chronological order, they only just submitted this to her. So it appears on the docket, right after this hearing. So that will be the next thing we cover. And that is where Mr. Baez gets involved. Okay. That's where Mr. Baez gets involved with this whole thing about the, trying to recuse the whole office. So, or disqualify. Oh, complicated. Well, I I don't know that either of them are that complicated. I don't know. I don't think either of them are really that complicated at this juncture. Well, okay, let me take that back. I think that we're Koberger, but this is probably not what people mean when they say that. But in my view, the only thing that could be maybe sort of complicated when it comes to Koberger is the garbage situation, which we've talked about in length. And I need to do another live stream about that because I have some additional follow-up with that, some case law and some other stuff. But as it relates to the IGG and the garbage, that is where it's really, for me, that's the part that could be complicated because, well, having said that, it might not be that complicated, but because we don't have all the information, it is complicated because we can't know for sure because we don't have all the information. But that is, like, to me, one of the most interesting things so far in terms of, you know, the entire thing being based on that DNA and IGG, and then the very specific facts as it pertains to the garbage where they lived. So. Oh, does he? I wasn't planning on covering the bond hearing, but if you're saying buys gets to shine, then I might. So she's reading that. So let me go forward a little bit here. Wow, Judge Kite reads. Wow, Judge Kite reads. Judge Kite. Okay, here we go. All right.
What's the state's position on Ms. Gardner's motion?
My position remains as of the last court date. I do think she's entitled to a bond hearing on her motion. We're prepared to respond, prepared to have that hearing. I just believe that for the record's sake and for appellate purposes and to avoid prejudice to the state of Florida, we need to handle the disqualification motion prior to proceeding with our hearing. Spoken with defense counsel this morning. I think we are close to requesting, I won't speak for them, I'll let them do that. We're close to requesting both the disqualification hearing. I floated some dates with defense counsel. I'll be requesting we set the motions filed by defense regarding the disqualification the week of March 11th and Ms. Gardner's Arthur hearing the week of March 25th. And I think that's very reasonable given the amount of evidence the state's going to have to present to prepare, file our written response to their bond motion and handle this other pending matter.
All right, let me,
So that lady is the lead prosecuting attorney. I forgot her name, but it was something funny. Not funny, but I wasn't sure how to pronounce it. But that's the lead. That's the lady. So if someone's disqualified, again, looking at the least, you know, in terms of what the state was saying, it could be her. Like, she would be the prosecutor that would be disqualified if anyone's disqualified.
first hear from you, Mr. Carter. What's your position?
Judge, I'm
Those
sure.
dates, on those dates.
Judge, I would need to speak to the other counsel involved in the case before I was able to confirm with the court.
Okay.
We've asked.
I mean, as far as the way that I'm reading your motion to schedule an evidentiary hearing and memorandum of law is that you believe that the state of Florida has had sufficient time. You wish to push forward, regardless of the court's ruling on a disqualification. Am I reading that incorrectly, or?
No, that's our position. And one of our major concerns is if we are successful on disqualification, we'd be back before the court with the new state attorney's office, and they'd be begging the court for more time to get up to speed on the case before they could have the evidentiary hearing. So it's our position, and our first available date is March 5th, and we'd ask for March 5th, Judge.
I can't believe Kurt was here. I can't believe Kurt was here. I don't even know. I don't know. I don't know. I don't know how that happened, but I just, that is insanity. Wow.
So
And that the fact that he, like, you know, actually was here, like, I just blows my mind.
into essentially your second
Oh, thank
sentence
you.
in the
This-
second
right,
paragraph,
right,
which says, while the law is clear that a trial judge upon the motion to disqualify him or her, which that's not necessarily the case, you're asking to disqualify the state, must first rule on the motion for disqualification.
So, Judge, that was referencing a motion to disqualify the trial judge where it's an all stop and the judge can't rule on any other motions. There is no case law similar for a motion to disqualify the state attorney.
So what he's saying by that is
So-
they brought the case law that was, in their view, most on point in terms of what they need, because there was nothing that was exactly on point.
Your position that it is not an all stop.
That is our position, Judge.
With, are you taking into consideration what has been alleged against the state. And to me, it's a little bit different. So let's say it's the evidence that they potentially would produce to the court, which is one of my concerns about hearing any motion. If there's contested evidence, right? And then that would be presented in front of the court. That's what I don't know. Like, obviously, I haven't seen it. I don't know. Do you have any of those concerns if we went forward with the bond hearing
Judge, I have some concerns.
based on your review?
But based on my review, I don't know any other way, Judge, because my
I mean,
client's been
it's
sitting in
just-
custody.
It's just crazy. Like, I don't even know how that happened. Like, did the algorithm suggest? I should have asked these questions while he was still here. My brain is still buffering on this. Like, did the algorithm suggest this? Like, maybe he's been following this. I don't think he's been covering this. But I don't know. I'm just so shocked. Like, I mean, I just don't even know. And it's also just really says a lot about him as a person. The fact that, like, you know, a channel that's like a baby channel, right? You know, that you would click on what they are streaming, you know, because some people would look at like, oh, well, like, how many subscribers do they have? You know, I don't know. I'm just, you know, shocked. Thank you, Flash Fan. That defense attorney is Patrick Crody. Thank you. I appreciate that, Candace. I appreciate that. It's just, I mean, I've quoted Kurt several times, many times on this channel, for different things. And like, I think there's been a time where I was telling the story about the Google Maps thing, and Kurt made a really good argument. That was on a Friday Night Frenzy with him, Rob and Runkle, and Kurt made a really strong argument against, because Runkle was saying that Google shouldn't be a fault. Anyway, that I'm not going to sidetrack us. Anyway, it's just like, oh my God, you know, I don't know. Wow.
For a long time now, the state had an awful long time to prepare for any evidentiary hearing on a bond. I mean, I think it's disingenuous for the state to say they need more time to prepare when they've already presented this case to a grand jury, and they're well aware of all the evidence out there. To our knowledge, they've completed all testing. So I wouldn't understand how they would need more time to prepare. But with regard to the state's, the court's position about whether or not we have concerns, we do have concerns. But the alternative is that Miss Gardner stays in custody until this disqualification issue is resolved.
Oh, thank you.
And I think, Judge, once you hear what we found out during the depositions this week,
thank you guys.
you're going to see that this is much, much bigger than any of us ever thought a week ago. And I can tell the court what happened.
Really?
Yes, Judge. I can tell the court what happened during the depositions this week if you would like to know.
So because you share in those concerns, right? And I'm concerned, and I've always been clear about that with the parties, right? It's ever since you all filed this motion with the court. To me, because there is no guidance in a situation like this is probably, I don't know if it's a first impression, but at least it hasn't been litigated on
Interesting.
a level.
Yeah,
It seems more practical.
that's big. So again, remember what I was just referencing, that he said, you know, there's no case law that's like exactly on point, or that's what I said about what he was saying. But she just echoed that. Let me back that up. This is a big deal. This is the big deal. And this is where it stands a chance, man. Look at this.
Because there is no guidance in a situation like this is probably, I don't know if it's a first impression, but at least
There's no guidance. It's probably could be first impression.
it hasn't been litigated on an appellate level.
So remember what she means there, right, guys, is because the way that you would handle this, right, you have to go, we've talked a lot about how this works with binding case law, right? Mandatory case law, where you have to, if a higher court, right, has ruled on something that is the same matter, right, or issue of, you know, here, like she said, issue of first impression means, right, that a higher level court has not dealt with this. And you start by going in order. So the next level court, so when she says, well,
It's
appellate level, right? It says appellate, but you know, when she says appellate level, that's because the first thing you would do is check to see, well, has the appellate, you know, that's to the next court above them. If that had happened, they would have to kind of follow that. Then that sets precedence. So you would go to the appellate court, and then you would go to the state, you know, the state Supreme Court. And then after that, you're looking at like, you know, in terms of mandatory binding precedent, you're looking at the U.S. Supreme Court. But in other words, it hasn't been done. So it's interesting. This could be something.
It seems more practical to me to handle the disqualification. I'll give you the time. I'll make the time.
Okay.
If you all are prepared, I
Wow.
want to do it sooner rather than later, and then I could still honor all of the things that you put into this motion. I'll give Ms. Gardner the hearing that she's entitled to.
Yes, Judge.
Right? But if you all have concerns about potential evidence that they would present in order to meet or not meet their burden, then I'd rather hear that out first. And I do understand the concern about getting up to speed. Let's say hypothetically I do disqualify the state attorney's office. I'm cognizant of that, but the state should be able to burn the midnight oil in my mind and get that prepared. So
Or midnight oil, she
Your
said.
Honor, this is Jesse Dreiser on behalf of Mr. Fernandez
And there's
and
Dreiser.
Mr. Hill is present, Mr. Tassoni as well.
Yeah.
Your Honor, I don't know how clearly I stated this.
Wait, I'm
in
gonna
our
back that up so we can
motion to
hear. Sorry, I'm gonna back.
I don't know.
Hear the him say who attorney is what who.
Your Honor, this is Jesse Dreiser on behalf of Mr. Fernandez, and we didn't do our now, and Mr. Hill is present, Mr. Tassoni as well. Your Honor, I don't know how clearly I stated this in our motion to
Okay.
disqualify. I don't know how
I
clearly.
think Patrick Crody then is he the other attorney besides Baez who's representing Shanna? That might be what that is.
For bias, not all people. You have to talk to the microphone.
I don't know how clearly I stated this in our wherefore clause, and I may amend to make this very clear.
Oh, good
It will
wherefore
be our position that not only are we asking you to disqualify the entire Fourth Judicial Circuit, when the governor, I assume, does the governor's assignment for the new prosecution team, we're going to want all of the electronic data to be sent to a new filter team so that there is no way that this can happen again.
Yeah, that's
So
what I'm
that the
saying.
new state attorney that gets the case has it completely sent through a filter team so they
Interesting.
don't end up
Did y'all hear
with our
that?
text messages,
Hold on. Did you guys hear that? Da-da-da-da-da-da-da.
so that there is no way that this can happen again. So that the new state attorney that
So that the new state attorney. Interesting.
gets the case has it
So
completely
it's almost like he's operating under the assumption that that lady's going to get kicked out.
sent through a filter team so they don't end up with our text messages, our emails,
Wow.
our attachments,
Wow.
our timelines, and every other thing
Wow.
that the state had access to and is in possession of. So that's going to be another delay.
By the way, guys, tomorrow's episode of Casey Anthony is going to be really, really, really good. Really good. Because we're getting to the end of the state's case in chief. And so I have a presentation we're going to talk about of like, what the heck was the deal with the backyard? We're going to go through that. We're going to compare certain things with when Casey was in and out of custody. And there's also something really shocking that I discovered as it pertains to Casey Anthony and has an overlap with Sarah Boone, which I will show you guys tomorrow. But then we're going to get to guess who takes the stand again. We have Lee, we have Cindy, right? We're also going to hear more about that duct tape and the heart-shaped sticker and all that. The state tries to sneak a doodle evidence from the jury, and that's freaking insane. And then we're going to get to the state resting, and then we're going to hear, in my view, probably the best and most exciting motion for a directed verdict I have ever seen. It's epic. It moved me to tears, to be honest. Like hearing it the first time as I was editing the video, it moved me to tears. It is so powerful. And yeah, so, and then Miss Burdick gets real feisty on her part when she's arguing. So it's going to be really exciting. Yeah, so just make sure if you guys are available, you tune in for that or watch a replay crew because it's going to be a not miss. And I will say too, anyone who's kind of hasn't been following the whole trial, I think that if anyone, not that this would pertain to anyone who's probably listening now, but just to say it, if anyone just joins in at that part, I think you will get a good idea of where we're at because again, it's the state resting. You're going to hear, and the motion for directed verdict, it's going to be in summary what the state's case what they think their case is, right? And then what the defense thinks is why the state's case sucks. And then again, also we're going to just be discussing sort of the culmination of all this stuff and what does this really mean? Where like they're resting their case, like this is their case. So it's a good point to join for anyone who hasn't followed the whole thing.
The state can't burn the midnight oil on because that's going to have to happen in our minds for this case to be secure and non-prejudicial to the defendant.
Thank you, Flash fan.
Do you want to tell me what your position is based on the discovery that you conducted?
Our position is we're ready to go. With the exception of time that we need to get the transcripts from the depositions, so I would say 10 days. The state did speak with us this morning. Their timeline was acceptable in terms of our issue. Bond issue is not our issue. That's Ms. Gardner's issue.
Okay.
Tangentially, though, it does affect, because what you're saying is, what if the state uses the document that I'm highly contesting, or the text messages that Ms. Gardner is highly contesting against Ms. Gardner in her bond hearing? That would pose a problem for me.
Okay.
Because again, it would be one more person, you or anyone else.
Okay. Now I can see why. This. Because I was wondering why I was wondering why the bond hearing was 7 hours. And I was like, what? Because normally it's pretty, Corey Richens has had a lot going on with trying to do with her bond hearings and stuff. So has P. Diddy, but those are kind of outliers. And like, typically it's pretty cut and dry, right? I was wondering why the bond hearing. Okay, now it makes sense because of what he just said. Because if the state's going to use in the bond hearing some of this information that is still up in the air about being attorney-client privilege, then I can understand it. Now it makes sense. Yep. Judge Percy. Is that Judge Belvin's last name? Because I only know him as Judge. I just in my mind he's Judge Belvin. Is that who you're talking about?
That would have access.
What are they accused of? Do you mean these defendants, Candace? They are accused of, they are charged with first-degree murder and like conspiracy to commit murder. And what was the third thing? I don't know if I still have that document. Let me see something real quick. Let me see if I can pull this up. Give me just a second here. Hold on. Let me find this. Let me go to the thingy-mabobber. That was, yeah. Hold on. Actually, what am I doing? What I will do is I will keep playing this while I'm pulling this up. Let's do that.
Or actual knowledge of what's in that document. So I don't have a suggestion there, but I do have the same concern that you were sharing this morning, for certain. I can't predict what they may or may not show.
Okay.
And Judge, we are going to supplement our motion as the court asked us to inform the court today. And we're going to move to actually dismiss the indictment, Judge, based on the fact that the state and its law enforcement officers, and this is sworn testimony, were reviewing both Ms. Gardner's iCloud return and her Google Drive return before it ever went through the taint team, that was knowing and intentional acts by the law enforcement team that was working with the state. And that when they had questions when reviewing those about whether or not something they were actually looking at was attorney-client privilege, they would call Ms. Stifler and ask her, describe it to her, and ask her if what they were looking at was in fact attorney-client privilege communications. And so it's our position that the spillage of her attorney-client information throughout the law enforcement teams, which are Category A witnesses expected to testify in this trial, will amount to sufficient prejudice that we can never put the genie back in the bottle and Ms. Gardner can never get a fair trial. I will let the court know that we have some research to do. We are not taking this lightly. We want to make sure that we are able to adequately support the assertion that I just made to the court before we file our supplement. But we do think that what we established during the depositions this week, in fact, one of the things we learned, Judge, is that my client's iMessages from her iCloud, which we all know did contain attorney-client communications, were circulated to most of the primary members.
Saying we know it did contain it. Remember, that's one of the things.
Before the taint agent, who was never trained and had no protocol and had never done this before he even looked at them, and that the spreadsheet with all these messages that was circulated was open and reviewed, and that the law enforcement members did in fact identify attorney-client communications order, right, in February of 2023. All of that was supposed to go through the taint agent before anyone that was part of the prosecution team looked at it.
So yeah, so I will definitely cover the bond hearing. I did see that press conference video that Flash fan is referencing, and it is insane. And at the time I didn't have the context for but I was like, holy shit, he's worked up and he doesn't do press conferences, and he said as much. But here, let me pull this up. I have the indictment. So let let's do this. Hold on. I have to unshare, reshare. Unshare, reshare. Let me pull my banner down. Okay. So the indictments here, right, are identical for both her and for Mario. And remember, they're still technically married, but they were like estranged. And that was her second husband. Okay. Her ex-husband and her first husband was Jared Bridegan, and that's who was killed. So the two of them, right, are indicted for murder in the first degree, conspiracy to commit murder. Oh, right. Solicitation to commit a capital felony. That's because they hired a third party, allegedly, in child abuse. And so the child abuse is pertaining to the fact that, so they hired Henry Tenon, who took a plea deal right off the bat, really early on, to testify against them in court. And so we covered that again on the other live stream. And so he was the person who they hired, and it was for some nominal amount of money. I feel like too. It was like, I don't remember how much, but it was like not much. And so he was like the hitman, so to speak, allegedly. And so the reason there's child abuse is because Jared Bridegan had remarried, had a new wife, and they had a baby who was like, or a toddler who was in the car when it happened. Now that toddler didn't get hurt, or baby, I don't know the age, didn't get hurt, but could have, right? So the child abuse, though, we went over the statute and all that, right? Is for that purpose. So the conspiracy, because they planned, there's conspiracy, right? More than one person. And then the solicitation is because they hired somebody. And they are seeking the death penalty against both of these folks. Okay. They are seeking the death penalty. So let me go back to the hearing. You guys remember Debt Be Heard when we had all the holiday themed sidebars? That was so fun. Okay, so, all right, we're back.
Okay. So what do you want me to do?
Judge, I would ask for 2 weeks for us to file our supplement to the.
Now, one thing I will say is I'm not entirely clear on what the motive is supposed to be. Rather than trying to read what people speculate on, it hasn't really come up. But one thing I will say is that when we saw the part of what we covered it last time was like there was what we covered the aggravating factors upon which the state is seeking the death penalty for both of these guys, and one of them had to do with the murder for pecuniary gain, which is like financial. So what I don't know yet, and I'm sure we'll learn when they go through all these death penalty motions, is what that gain was, because I don't really understand. Like, he was remarried, right? So normally if you think that, what first thing comes to mind is like life insurance policy, right? Now I should also mention that Shanna is very wealthy and comes from a wealthy family. She's got plenty of money. I don't really know, but even if she wasn't, right, I don't know how there would be any pecuniary gain for this to happen. My thought is my instinct would have been it was maybe more like a child custody thing. You know what I mean? Like, because that's what usually you see one or the other when it comes to people killing their ex-spouses or people that are divorced or whatever, or in the process of a divorce or separations, So I don't know yet what was going on, but we will find out as we go along, I'm sure. But yeah, so she was married to Jared Bridegan. They got divorced. He remarried, had new kids. She has kids from her marriage to him. I don't know the details yet of how that goes with the custody, right? And then, and the kid, her kids are older. What we could do, actually, we should do this. There's body cam of the arrest. We should watch that because you get an idea of the age of her kids there. We should watch that because it is interesting. We should watch that. Maybe we'll watch that after the hearing. And so, what was I going to say? Yeah, but so then she was married to Mario, but apparently they were estranged. So the whole situation is kind of funny, right? Because, and why was he involved? This doesn't seem like a middleman situation, kind of like you can compare it to the Adelsons where they had, what's her face? Oh my God, I'm blanking on her name. The girl, why am I blanking on her name? The middle person who found the hitman or whatever. It doesn't seem like that's the case here. It seems like looking at the charges, right? It's like they were equal. The two of them were conspiring together equally. and then hired a hitman. So yeah, it's weird. It's very weird. Thank you, Flash Fan. I have gone through and saved all the hearings. I did not save the bond hearing because I was like, I don't know if I'm gonna cover that, but I did save all the other ones so far. It took me quite some time. I went through and put them all in chronological order, so that I could catalog it with the documents. So just everything's in chronological order. So I did not have the bond hearing. And I'm sure I could find the body cam, but I do appreciate you putting that. Yeah, it is bizarre. It is bizarre because usually it's more clear, right? Like this is a puzzler. Now, having said that, the evidence against them, from what I understand so far, is pretty strong in the sense that Henry Tenon is going to testify. You know what I mean? Because they struck that plea deal. Like what the impression I've had people saying is like, this is a much more cut and dry case because they've got, this testimony that they will have from him. Now, who knows what he'll say, right? But that's the plan because his plea deal is contingent upon him testifying truthfully. And that when I say that, that's according to the state, truthfully. Because if he doesn't testify truthfully in the eyes of the state, then he doesn't get the sweet plea deal that they gave him. So, but it'll be interesting. It'll be interesting.
Qualify. I don't know how long the state would need to respond to that. And then
So that's still putting you off the timeline that you're indicating.
I know, Judge, but I'm stuck between the rock and a hard place.
Now, Jared Bridegan was a Microsoft exec. Let me pull this up. So he, again, we're thinking about like, it kind of reminds me of the murder that just happened with the United Healthcare dude. So he was. Oh, interesting. This just popped up. Apparently, guardianship of the two children of Jared Bridegan has been awarded to Shanna's parents. How is that happening? Hold on. Okay, so the children that are now 12, these are the children that were of Jared and Shanna when they were married. They've been living with Shanna's parents since Shanna's arrest. Okay, during her and Bridegan's ongoing legal battles and contentious relations. So, but the thing is, it's like, what are the legal battles of, right? Her parents are co-founders of the highly successful Stampin Up arts and crafts company and fixtures in the Mormon community in Utah. Oh yeah, by the way, there's an overlap with all that, which is insane. Has to overlap with Utah and Mormons. Bridegan's parents, the twins' paternal grandparents, filed a lawsuit asking for unsupervised visitation rights and contested the Gardner's petition for guardianship. Interesting. Let's see. So what they said, so what ended up happening there is that because of the fact that, okay, yeah, the maternal grandparents have had custody of the children for over a year and have been living with them for almost 2 years. And that's why. And Shanna has consented to appointing her parents as guardians. Let's see what this says. Okay, so the daughter in the car was 2 years old. And nothing appeared to have been stolen. His wife had just spoken with him, his new wife, right? And nothing was out of the ordinary. He was a 33-year-old Microsoft executive and a father of 4. He had 2 children with his ex-wife, Shanna, and lived in Jacksonville Beach with his current wife. Oh, sorry. They live in St. Augustine. Okay. And then, yes, they arrested Henry Tenon. I want to get to why they thought there was contentious legal battles going on. So here we go. What was the motive for killing Jared Bridegan? An arrest warrant states the investigation into Bridegan's background revealed a highly acrimonious divorce and a contentious relationship with both Gardner and Fernand. What? Hold on. Okay. It looks like Jared had a contentious relationship with both Shanna and separately with Mario. But again, if those two were estranged, then I don't really understand. Okay, it says, what happened in the divorce? Gardner's from Utah met Bridegan while visiting a friend in Florida. They got married in Salt Lake City. Okay. So Mario was Shanna's personal trainer, right, while they were married still. And she had an affair with him. He was her personal trainer. Okay. She filed for divorce in 2015. So that's what's crazy is this murder happened in 2022. She filed for divorce. See, usually these things happen a lot closer in time, right? When there's like an acrimonious divorce or child custody and all that. So he filed for divorce in February 2015 and sought primary custody. One document states the parenting plan is clearly an issue and the parents are unable to agree. The disagreement of the parents at this point now extends well beyond mere time sharing and goes into issues of mental health and well-being of the children. Wow. Another motion for relief states the husband is a stay-at-home father while being a full-time student through the marriage. Wait, what? The husband is a stay-at-home father while being a full-time student throughout the marriage, completing his Bachelor of Arts degree and is presently engaged in an online Master of Arts program. I wonder if this is talking about her and Mario. The wife has provided the sole support to the family through her regular and recurring gifts from her family. Okay, right, because her family's rich. The parties have regularly received a stipend from the wife's family exceeding $8,500 per month, which has actually enabled her husband to further his degree programs. Oh, what? This is weird. Are they talking about? So the reason I'm like, who are they talking about? Because Jared was a Microsoft executive, so I don't see how he would be in school at the same time. That's why I assumed that was talking about Mario. She married Mario in 2018. Let me just see here. How did she have an affair if they were already divorced? I don't know. This is weird. Because see, now it's saying that she met, okay, well, according to Shanna, she says she met Mario in 2018 at a CrossFit gym. But that would have been after the divorce to Jared. You know what I wonder? I wonder if what it is that Jared is now or was now a Microsoft exec, and that if back in their early part of their marriage, he was in school. Maybe that's what it is. Maybe that's what it is. That would make sense. And so essentially, okay. So essentially what this sounds like is that Jared, when he was married to Shanna, he was a stay-at-home dad and like still in school. And like basically the way that this family was supported was by getting money from her parents is what it kind of sounds like. But then later on, they got divorced, right? And they both remarried. And then I guess he became a Microsoft exec at that juncture. I still don't quite, it's just odd that 7 years after the filing for divorce, they're still fighting over things. That's really weird. Like enough, like, okay, when it comes to enough that you're going to, not that anyone should, but again, usually the murder is going to be like more like emotional at the moment when things are first going down, that's what's weird. Let me see here. Okay, so the reason he was getting a Bachelor of Arts degree is because in terms of him being a Microsoft exec, he was a design manager. So that makes sense. So that was him in school. Okay. Wow, they're younger. Shanna is the same age as me, and Jared was a year younger than me. That's wild. Oh my God. And Bridegan's new wife was from Charlotte, North Carolina. That's insane. Wow. Yeah, this is weird though. It's still, and then how did Mario get involved? I don't know. So that's like gives us some background, but it still seems weird. So I don't know. What do you guys think? They talk about, do you mean Shanna and Mario testifying against each other? They can't because of spousal privilege. They cannot. The state cannot. Now, okay, the defense could. Let me put it this way. The state cannot call them to testify against each other because of spousal privilege. Unless for some reason they wanted to like waive that, but they wouldn't do that. In other words, they can't be forced to testify against each other. Now, what could happen is if they want, they could consent and not be forced, right? They could consent to testify, well, to take the stand in the defense case in chief. But still, they would have to be forced to testify in the sense that they would have to be like subpoenaed as a witness. So the only way that would happen is if they like choose to waive spousal privilege. I don't see any of that happening unless they decide to sever. It seems like to me what's happening so far is it seems like they feel like their powers combined, they're going to take on the state, right? And that it's stronger that way versus trying to throw each other under the bus. And maybe that's because the evidence that connects one of them to this crime connects both of them. That would make sense. If that's the case, then how are you going to throw the other one under the bus, right? Maybe they feel like, again, if it's like if the evidence connects both of them to the case, then the best thing they can do is say that neither of them should, I don't know yet what the strategy is going to be because we haven't gotten that far into it. But yeah, I mean, if they wanted to employ a strategy, that was throwing each other under the bus, they would have to first start by like making a joint motion to sever. And then even still, they would still have to, and I guess this would happen at that point, then they would have to consent to waiving spousal privilege, which if they want to have that strategy of throwing each other under the bus, they would do that, right? That would be the whole point, would be to do that. Right. That's what right. If they were going to sever, I think they would have already did. Right. That's what I'm thinking too. So that would point to that the evidence more than likely connects both of them similarly, like, you know what I mean? To where would be not an advantage, in that matter.
So
Do you want a moment to try to talk to your colleagues?
yeah, well,
Really, client.
yeah,
My client.
yeah, let me, one moment.
So it does. I just wanted to touch on this because again, the pecuniary gain. I'm wondering. You know what I wonder? This is my. Hold on. Okay, let me roll this. Where is it? Where is it? Here it is. Okay. After reading that bit of background, the only thing I can think about for the pecuniary gain is this, because Shanna's loaded. She doesn't need the money from him. So here's the thing. So I was thinking that he was rich because he's a Microsoft exec, but now it looks like he did not become that until later after they were divorced. So again, we know that now they were married and essentially it wasn't even her that was supporting the family. It was her parents by sending them a stipend of $8,500 a month or whatever. And that's how the family was supported. He was in school. Okay. They go through a contentious divorce, and then he becomes a Microsoft exec. Common sense would tell you he's making a lot of money at that point, right? That's what common sense would say. And so I think this is what the state will try to allege in terms of the theory. This is that while Shanna did not need this money, right? You know how like there's like child support and stuff. That's not like, she doesn't need that money from him. My guess is that just because to get back at him over this contentious divorce and whatever was going on in their personal life, my guess is that the reason that they were still trying to litigate that is to try to say that he owes her money. This would be my guess, speculation, that he owes her money for all that time that she quote unquote supported him, but it was really her family. So what I mean by that, like, again, she like that money was paying for him to go to school, right? So if like, in other words, if that money, which was being given to her as a gift from her parents, quote unquote gift is from her parents, but then it's her money. And that money was paying for for him to go to school. And then subsequent to that, he goes to school, gets these 2 degrees. And then after that, gets this job where now he's a Microsoft. And now that's after their divorce, right? Lands this job. And now he's probably rich, making a lot more money. Maybe what she's trying to say, or was saying, maybe when it came to all the, this would have been like the family law stuff, right? She would have been saying like, hey, now that you have the money, you owe me. That's my guess. That's my speculation. Again, it's silly because it wasn't really her money to begin with. And also she doesn't need the money. But if it's out of like punishment or vengeance or whatever, that's where I think maybe the state could be going with this, with the pecuniary gain. Because I was puzzled by that initially. That's what I'm wondering. That she's like, you owe me that money back. And then if they're fighting over that, I wonder if that's because that's so far the most insight we have into what the hell could have happened here and why, basically. Does that make sense to y'all? Yeah, she's rich, but I don't know that it's from her own work. Like her family's company, Stampin Up or whatever. That's why in the thumbnail I put Stampin Up. It's in one of the windows. That family is loaded because of that company. And I remember hearing at one point that like Shanna and like her other siblings like have never worked in their lives or whatever. However, I did say when I was reading through this to you guys just a second ago of the background stuff that she did start like a baking company after she got married to Mario. I don't know how much money that's making, but usually if you're starting up a new company in any category, but especially when it's in the food industry, usually you're taking a loss initially. I would also say that the way that she got the money to start that company would have been definitely from her parents. I wonder if it's more of like a hobby versus like to be profitable. Anyway, and I don't even remember what it was called, but some sort of baking company. But yeah, again, I think she's rich because it's like family money, in other words. And now Mario, he was a personal trainer, so I don't really know how he's affording his defense counsel, but maybe Shanna, right? Maybe Shanna. Interesting.
Judge, I've talked to my client and
I wonder if
we agree
that's,
with the court-
and
with the
now I'm
court
like, I wonder if her parents are paying for his defense counsel. I wonder.
assessment earlier that if we can resolve the disqualification motion in a timely manner, we
Yeah,
can
but
set the bond motion.
personal oh my God, what personal trainer? I don't know, man. I don't know. I wonder, again, considering her parents supported both her and her husband when it was her first husband, I wonder if they're doing the same thing now, especially because they're still married technically, right? So maybe they still have joint access to funds. I would say, though, if her parents think that maybe, okay, if her parents think it would help him to have really good defense attorneys, knowing that she's going to be charged at some point and they're going to be tried together, do you see where I'm going with this? I could see where I could see where they might be like, no, it's worth it. We need to get him a really good defense team because they're going to be fighting as a unit against the state type thing, like by helping him, it's helping her. I don't know.
Okay.
And that satisfies the concerns that Mr. Fernandez has well around.
Okay. And you talked to him about it. I mean.
We're in a different posture. I don't need to talk to Mr. Fernandez.
Right. Well, this is the thing. You all know I have not seen one shred of anything, and before.
So what she means by that, one shred of anything, she's not seen any of this material that is potentially, attorney-client privilege. She has not seen it yet, and she can't. They're gonna bring in someone separately to do this for like in camera.
I was going to ask you, is it your thought? So you're going to supplement, right? The state's going to respond. Is it your thought that I do need to?
They're going to bring in a special master because I saw that on the docket.
The chief judge to appoint another judge to.
There it is. Keep watching. There it is. Another judge. Yep, the special master.
Is material, or is there an agreement on it?
Yep.
I spoke to the state and Mr. Carodi, and I'm just addressed for the record. I don't believe we need another court. The emails, the text messages, everyone and their brother had them in this case, far before Nextpoint even became an issue. And the documents that the state intends on using against my client, they've seen, they've read, they intend on using them. If the court,
so what he is saying is the opposite of what the state was saying. The state was like, we didn't see them, we didn't have access to them, we aren't going to use them. He's saying the opposite.
Document, it makes no difference. That privilege has been eviscerated unwillingly by the defense. And I would say that if there was any concern for the court, I would waive any ability to recuse the court based on this very limited issue, because, if the court has some concern, like, well, then I'll see it and the defense will try to recuse me. Absolutely not. I think this court is the proper place to hash all of this out.
All right. Am I understanding? Before, there was an agreement that certain documents, certain
Yes.
communications,
Yes.
those things, my understanding was there was a great majority of the information that you all were talking about was agreed to by the state of Florida, that was attorney-client privilege. Is
Yes.
that still
Yes.
the case? Or are you still, my understanding was only kind of one document or thing on Mr. Fernandez's part. But the state indicated it was evidence. This defense said it was attorney-client privilege, and it was my understanding
That
that
must
it was
be,
only one contested document. Is that
I think that is the, what she's referencing there, I think is the confidential communications folder
the
thing.
case?
There's
Right,
one,
so-
there's one contested document that the state is in possession of, admits that they've looked at and intends on using. That's what you're speaking of specifically.
Right, and so I'm
There are-
asking, is that still the case, yes or no?
Yes, there are hundreds of what the state agreed to were privileged communications that were uploaded to Nextpoint that the agents had access to. Their position is, yes, they were privileged, but no, we have never looked at them. No one has ever looked at them, albeit everyone had access to them. Their position is no one's ever seen them,
Right,
except for the one document. So
right.
Right, so
That's
I think-
correct.
sorry.
He's saying that correct. Yeah.
I don't mean to interrupt you guys,
You're fine.
but I somewhat agree with what's being said. I do think that the depositions make clear, and that's been, the information brought out depositions is the information contained in the state's file written response. But we have been clear from the beginning, there was an agreement between parties to send cell phone devices, MacBooks, Apple Watch, and an iPad through a taint team. The Jacksonville Beach Police Department executed over 70 search warrants in this case, including to Google and to iCloud. They received that information directly as the applicant and custodian of those records. Those records are at Jacksonville Beach Police Department, just like any other evidence for any case to be stored with the presiding law enforcement agency. There is one document that we discovered while reviewing this evidence that I believe is evidence. I don't believe it's one, it's communication.
Okay.
Or two, it's confidential.
Okay.
Anyway, a privileged attorney.
Okay. And she's referring to what has been referenced by the defense as the confidential communication folder. Now remember, in the state's objection that we just read earlier tonight, they said that what was contained in this folder or whatever was was communications between Mario and Henry Tenon. And that's why she's saying, I don't see it as privilege, I see it as evidence.
My communication. That document was brought to my attention by our analyst. I reviewed it. I determined that there was nothing about it that suggested it was from an attorney to an attorney, etc. I mentioned it to Mr. Dreiser.
It does seem to me like at this juncture, kind of like what Kurt was saying, it does seem to me like maybe that the defense is trying to argue that counts as privileged, but it wasn't really privileged. Okay. However, that's still, as far as the rest of the information that was referenced earlier, like all the stuff that was on Nextpoint, right? What it sounds like is that the state is saying, again, they didn't review it, they didn't look at it, and they don't intend to use it. And then the defense is saying literally the opposite. They did intend it. In other words, all of that, no one's contesting that information is not attorney-client privilege. If everyone's on board with that, is all attorney-client privilege, right? So in other words, the only thing that the state is saying is not attorney-client privilege is this confidential communications folder. They're saying all the emails and the texts and whatever, everything that was on Nextpoint was attorney-client privilege. But what they're saying is that they didn't look at it, they didn't review it, they're not going to use it. And then the defense is saying they did review it and they did look at it and they are going to use it. So that's where we're at right now.
And we are disputing that one document. The rest of what they're talking about is the state of Florida never had possession of any of these items. They're in the possession of the law enforcement agency. Once we realized that there were attorney-client privileges, documents, or text messages on this information, which we had purposefully taken folders, left them sealed and zipped and didn't review them. The analysts were reviewing other evidence.
The defense disagrees with that.
Those were then sent through the taint team. The state of Florida and law enforcement has
This
never
is
read
really-
any emails.
This is really interesting because what they're saying really matters and it's completely an opposite, right? Like, it sounds like to me, if they're correct, and they're going to have to do that in-camera thing, if it's true that, again, what's in that confidential communications folder is evidence and is not attorney-client privilege, that's coming in, okay? But what's really interesting is really how they're completely at opposite ends with the rest of this stuff that was on Nextpoint. All in agreement that it's attorney-client privilege, but state saying, we didn't read it, we're not going to use it, and the defense saying they read it, they're going to use it.
Text messages. any client communications other than this one document. The state attorney's office agrees. I read this one document, I intend to use it. So I just want to be clear about all of that. because
Literally what I just said.
wants to dismiss the indictment and needs to do research to adequately support his assertions. I just want to be clear at this point, they're assertions. We have no, I haven't seen their supplemental motion yet. I think I have previously said that the communications, I took Mr. Dreiser and Mr. Carudi and Mr. Dreiser's word that whatever emails and text messages were privileged, I took their word that they were privileged. We didn't look at them, we removed them, we deleted them, we sent them through tape teams. To the best of our ability, we tried with good faith never to purposefully or intentionally read anything. Any disclosures or any possessions were inadvertent, and we took whatever steps to remediate our possession of these when we realized that we had things we were not supposed to have.
Can I just ask you a question?
Oh,
Do you believe, based on what Mr. Dreiser is saying, okay, that the court could just look at metadata and not the exhibit? Do you understand what I'm
I
asking?
understand what you're saying.
So
I don't think you-
file, give me a second.
Yes, ma'am.
So file A, okay, if I don't need to see the contents of file A, that's why I'm asking all this question. I don't see the content of it. If you all agree that it is in fact attorney-client privilege, there will be no need for the
Right.
court to examine that document, then to determine if whoever has access to it. That's what I'm
Right.
asking. Are y'all agreeing or are you not agreeing? Or is it?
my understanding, like I was just saying, is I thought they were all in agreement about the next point stuff, that was all attorney-client, but she's verifying.
Just as to one document, or are you all saying it's multiple documents? And if it's multiple documents and there's no agreement, I'm gonna disagree with you, Mr. Dreiser. In an abundance of caution, I ask the Chief Judge to have someone else review it, settle your disputes, and then I'll look at the metadata.
Right.
And my response to that would be,
That's
I haven't seen
logical.
anything or reviewed anything other than the document we're disputing is privileged.
Two.
2 documents. Actually, one of them I reviewed, one of them I was told about the contents. I have not seen or reviewed any of the, I think you said 66.
It was also
emails.
sent to you in the same
Oh,
email,
yes.
two
So
documents.
y'all will talk to each other. Is there an agreement or is it not?
It's a little bit more complicated. I know
I'm not
I'm not-
here.
we're not in agreement that the one document that is going to have to be reviewed by the court. The
Okay.
other documents, which are emails, text messages, and
That's
phone
the next
calls,
point
there
stuff.
are over 100 at least communications. There's no question that they're privileged, and there's no question that they were uploaded to Nextpoint. The only and I wouldn't allow, it would be over serious objection by the defense that anyone ever get to look at those. So no court is ever going to get to look at
Okay,
those.
Give me a moment. Do you agree?
I do not. I believe that.
I
our
love this.
argument,
I love it.
Because my testimony and our response, and what I believe will come out of the hearing, is nobody from
Oh,
law enforcement,
boy.
the state attorney's office looked at any of those items that they're talking about, the text messages.
I agree with you.
So why aren't you agreeing that they're attorney-client privilege?
Because I don't know what they say, and I don't dispute that there are communications between them and their clients. My issue is the prejudice, which is the second prong of their motion. If these emails and text messages are about scheduling, and the court's going to disqualify and dismiss an indictment because we had theoretical access
Oh,
that we could potentially hypothetically open a scheduling text message, I think
okay.
the court needs to weigh that.
Interesting. Here's what she's saying. She's saying first, I don't know. So it did seem like initially, that's what I said. I thought they were saying, yeah, these are definitely privileged, right? That's what I thought. And I think the reason that was sort of unclear and the judge was asking for qualification is because essentially yeah, she's pushing back on it. She's saying this, that like, in other words, she's saying, yeah, they're all privileged, but she's not saying it because what she's saying is, well, okay, let's say it's attorney-client privilege, but they're just talking about scheduling. That's not prejudicial. Oh boy. So she's saying we don't know. We don't know. Okay. Again, I think it is kind of conceding that it is all attorney-client privilege because that's the reason she didn't look at it. She's saying, I don't know what they say because I didn't look at it. Well, why didn't you look at it? Why are you saying you didn't look at it? Defense says she did. Why is she saying she didn't look at it? Well, because she thinks it's privileged, right? Obviously. But what she's saying is, well, if it's privileged, but if it's like scheduling text messages, that's not prejudicial.
How prejudicial the mere access is. Putting aside
I
the
know.
fact that,
Me too.
the fact that I have a closed sealed envelope on a table next to me, it matters to me what's in that envelope because they're saying it's a communication. I'm not disputing that. I take them at their word. But what it contains is relevant to the remedy that they are seeking because they have to prove that they've been materially prejudiced in some way. The state of Florida has somehow inherited a benefit to trial.
Well, because of this argument, here's where I see this going. Because of what she's arguing, they're going to have to look at all the stuff. They're going to have to do it. They're going to have to go through all the stuff too, not just the contested document. Because of what she's saying, it does make it contested about the contents of the emails. I'm just going to call it the Nextpoint data because it's just easier.
By having access to this information, that I will have evidence I should not have had, that I will have trial strategy I would have otherwise not known. So I believe that an independent magistrate should review it. And I will point out that when we had this agreement in front of Judge Carbula on their motion for protective orders to stop us from doing a forensic extraction of phones, they were in favor of a magistrate reviewing everything. So At some point, we were all in agreement to detainting. They wanted a magistrate to review all the communications, remove attorney-client and marital privilege. The court said, no, the state can look at marital privilege. There was no court order. We agreed. We don't want to look at attorney-client privilege. We don't want to look at it. We have no intention of looking at it. Anything that has happened has been inadvertent.
What?
And has not prejudiced them. So
But you just said you don't care if it's attorney-client, but it's text messages.
The
So,
contents
or
of those
sorry,
messages
scheduling text messages.
are relevant to that prejudice, that finding of prejudice or non-prejudice.
With the exception of 2 documents
Yes, and I'm
titled confidential communications sent by Miss Butler
Wow.
to Miss Stifler
Wow.
before the taint agent ever got a chance to look at them. And our expert's going to come in
I'm fine
here.
with the court reviewing those 2 documents because I don't believe their communications are privileged.
Our expert's going to,
They're contesting them.
and our expert's going to come into this courtroom and
Oh my
say
God.
that on such and such a date,
Wow.
Mr. Fernandez emailed
Wow.
our office and our attorneys only those documents. The taint agent is going to
Wow.
come in and say, had I seen the email with the attachments, they would have been privileged and I would have filtered them out. That's what we heard this week in the testimony.
Okay, I can tell you what I mean. So that testimony was in hearings or in camera, so we didn't. So here's the thing. Interesting. This is smart by the defense. So what this is saying is that, you know, there's the argument again, right? This is that folder where it sounds like it's communications between Henry and Mario, and where the state is saying it's evidence, and that's where it's like we don't know what's in it. Is it really attorney-client privilege? Okay, so this is where we're getting into kind of like the P. Diddy thing, right? Because he's saying that the taint attorney is going to come in and say, had he seen it first, because it was sent over, emailed out before he saw it, he's just saying, had I seen it first, I would have qualified, I would have categorized it as privilege. Now, the reason he would have done that is because it was labeled confidential conversations. This is going to get really spicy. I'll tell you why. Because what's going to happen after that, I'm seeing into the future here. What's going to happen after that is they're going to say, well, okay, that's correct. The taint attorney is doing his job by saying he would have filtered that out. What they're probably going to then argue with the state is that if once reviewed it, right, the taint attorney would have determined it was not actually it wasn't attorney-client privilege, right? So in other words, there could be dispute over the labeling of it, and that it would have been filtered out via the taint attorney that way versus the actual contents, if that makes sense. I think that's where this is going to go.
It is very clear to me that sooner rather than later, and when I say sooner, does Gardner share the same concern?
Judge,
With the same,
our concern is slightly different in that, you know, Ms. Stifler spoke about there was an agreement with the cell phones, and somehow that agreement didn't apply to her iCloud that was seized after the agreement that everyone knows has the same text messages that are on her phone. And so I guess what I'm hearing the state say is that because law enforcement couldn't look at the phone, they went and got her iCloud.
I just want to be clear about that. What I'm saying is we had an agreement, we attempted to honor it. We were dealing with hundreds and hundreds and hundreds of megabytes of data. We did our best to send it through the filter team. We made extensive efforts to prevent.
And this does touch on something that is really relevant right now and will continue to be relevant, right? With these trials with, you know, BK is another example, but there's tons of trials where because of the way everything is digital, right? There's so much data, right? Like terabytes and terabytes and terabytes, and everything is like preserved. And you know, what's interesting is that, like, even though it's all like zipped or compressed and whatever the file size, the information itself is no different than if it was all printed. Like, imagine like all the text conversations you've had with certain people, and then all the Google search and all this, like all this like it's all the data, all of the datas, right? Of all the things and all the social media and all that. And imagine if you were to like make it into a hard copy and print it out, right? That's what it's still like for these attorneys that have to review it. It's no different. It's not just because it takes up less space to have it digital and then instead of on paper, doesn't mean that it actually is smaller, right? I mean, that's my point. So then when you've got terabytes of it, it's like, imagine if you were like print all that out or make it into a hard copy, it would be like, I don't even know. Can't even fathom it. But it is interesting because this didn't used to be the case, right? Because it used to be that stuff wasn't kept forever. There wouldn't have been as much, you know what I mean? You would be dealing with maybe handwritten letters or, you know, eyewitness of conversations, shit like that.
My privilege, the 2 documents he's referring to are just evidence. I had no idea they were emailed to Mr. Rice by his client. I found them from an independent source. But I just want to be clear because they keep saying these things on the record that I dispute. And I just want to clarify the record. I think that we need an independent magistrate to review everything because I think that prejudice needs to be determined. And Mr. Dreiser and I are agreeing whether the contents of this document are even a communication, then I'm not comfortable with Your Honor reviewing it.
I've said this from the outset. A court hearing a case of this magnitude, okay?
I will say, I think that it's pretty clear that they need a special master. I think that in my opinion, the reason why the Mario's defense team is saying, no, we don't want one. I think it's kind of because they are saying, Judge, we don't need that because you should just, this shouldn't even be, in other words, this shouldn't even be a topic of discussion because it's clear, like their motion needs to be granted. It's clear that this was a attorney-client privilege. Like, in other words, all their arguments are correct. It's like, where's the gray area here? There is no gray area. Like, that's what they're saying. And like by appointing a special master, it's like as if to say there is gray area. But also I wonder if like they know that maybe some of this stuff is on the fence of counting, like especially the things that are really probably the most at odds, which is that again, that confidential communications folder that maybe is just really bad evidence and not confidential communications. Yeah.
Want to avoid any appearance. I appreciate the
Appearance of impropriety. Yeah.
We
I
don't have to.
appreciate the thought
Right.
expressed by you, Mr. Dreiser,
Yeah.
but my concern runs deeper than that. Okay, so
Yeah.
I've said it from the outset.
I mean, she's making the right decision, in my opinion.
I'm the one that offered it. I've talked to
I think
Chief
so.
Judge Day, and he's willing to extend.
I really like her. I really like her. I love how she's like, I appreciate your thoughtfulness, because what he was saying was like, Judge, we really want this to stay with you, which again, might be for the reasons I just mentioned, but that, I just like how she's handling this. But I think she's making the right call.
However, I am going to request, it is very apparent to me that that is a necessity. And I am also cognizant of the time frame and the work that all parties have put into it, both the defense and the state attorney. That's why I need a clear understanding of where your agreements are, where your disagreements are, because I don't want to send this to another judge with you all still essentially disputing or arguing about what the magistrate is or the other judge is going to look at. Okay?
Yeah.
So I'm going to ask the chief judge to appoint another judge to review these materials. I don't want to have access to it. I don't want to review it for a number of reasons. And I think it's only judicious and fair that if it is contested, what these documents
I agree. I
are,
love her name too.
whether they're privileged or not. A judge then ultimately, let's say we go through hypothetically an entire trial, there would be no way to any imposition I would have. Like, I don't want to have access to something that apparently may or may not
Yes.
rightfully be a part of this case.
Yeah.
What I do need the parties to do is based on your discovery. So we have these initial motions. Ms. Gardner says she's going to amend. Mr. Dreiser, are you amending or no?
If I did, it would be of no real significance, just to make sure my remedy is clear and maybe add what we believe we learned in the depositions. It would not be of any significant,
Okay.
but I'll have it done whenever.
Interesting.
This is what I need.
Remember, one of the state's things that they were complaining about in their objection was that they said that the remedies, they were poo-pooing the remedies, of the defense's remedies, that they weren't the right ones or there wasn't enough. They didn't give enough offers to remedy this. And so it's smart because he's saying, like, if I do amend it, it'll be to add to the remedies there. So
All of you. I need you to supplement both pleadings with what is in fact contested, okay? What is agreed to and not agreed to. The agreement should be, in my mind, the first part of the supplement. These now two documents that the state has admitted you are in, so that is the first part. The second part should be what you all do not agree to, what you want the magistrate to look at, so you can, out of this terabytes and terabytes of information, to hone in. And this is all for efficiency, and also if you want a decision done quickly, that you all kind of narrow the issues for the judge. I'm going to ask the chief judge to make the appointment. He should be able to do it hopefully by the beginning of next week. I need you all to supplement. How long would you all need to identify those things?
Despite our talking on the record today, I think for the most part, we actually agree on a lot of information.
I agree with that.
So
Oh, that's not the impression you've given me.
that's
I
what I'm
remember
going
that
for.
one. Yes.
Mr. Dreiser and I-
why are they zooming in on that lady?
This morning, I think a lot of these things there's little dispute as to certain pieces of the evidence. Our
Who's that?
dispute is to the law and the remedy. So we will get together and we will come to some
So-
understanding.
Well, Matt,
What I'm understanding from you is that you
Camera
want the magistrate or the judge to look at certain portions that you have not seen in order to say if it's to separate that these documents or these files or these, whatever it is, this is related to scheduling, therefore.
Right, I don't know what they are, but I think it is germane to their remedy they're seeking as to whether it prejudices them or not. The fact that I merely have access to their scheduling, I mean, I'm using that as an example. Because
Right. It's the only, you know why? It's the only example she could give of something that might actually be attorney and client privilege, but could count as not prejudicial if it's just talking about scheduling. But literally, that's the only example she could possibly give. And that's why she's using the same example.
Very big difference if they're discussing their trial strategy versus if they're discussing scheduling.
From your deposition, were you able to kind of
Man,
like narrow that down, or is it just hundreds and hundreds of files or things, or?
I narrowed the scope of the depositions to the documents that are in dispute. The other emails,
How about we start with that?
the other
What do
email,
you all think about that?
here's the
Start
problem.
with that.
Here's the real next big issue with another magistrate reviewing all the emails, which in a vacuum, I don't have a problem with it. That magistrate, what Mrs. Stifler was referring to in the initial hearing, was going to be a magistrate, a special prosecutor, or a filter team person. I would have had no problem because they're totally isolated. And I assure you that person would have never reached out to Ms. Stifler to find out whether something was or was not privileged. But in this case, if the magistrate's going to do that, and the magistrate may have, or the circuit court judge, whoever Judge Day appoints, and then has questions, the state attorney's office is going to have to bring in a special prosecutor to handle those hearings. It'll be like a federal castigar hearing where the AUSAs have a whole nother team to handle the hearing, because during that hearing, they would be potentially accessed or being asked questions or being asked to argue
Go
that.
back to my original question.
Yes,
What about we start with the two documents that you all can test,
that's fine with me.
and then we table what Ms. Stifler is suggesting?
Sure.
Then you all don't have a supplement. You all can identify, we know what it is, right?
Absolutely. There's no confusion about those documents, who had them, when they had them, what they intend on using. That would be very simple for this. There still needs witnesses and a hearing to hear the timeline. But yes, we can absolutely start there and perhaps finish there.
That seems more prudent.
Yes, ma'am.
Do you agree?
I'm agreeing.
okay.
There we go.
Yay.
Where's Ms. Gardner in all this? Do you agree or no?
Yeah, Judge, we're going to supplement. I think our basis is going to be a little different. And that is, we believe that what we would call the state's effort, and by state, we mean the law enforcement team that's working with the state attorney's office, right? One state
Right. Gotcha.
organization. That our concern is the effort to do an end around the court's prior order regarding the taint team by looking at the iMessages from the iCloud and the Google returns. So I don't think there's a dispute that there were attorney-client communications on, on those returns.
Is this something that you discovered during the depositions?
Yes, we had no idea. We had no idea that anyone had looked at her iMessages before the taint team.
The other thing is that it could be different too between what discovery that was, on this Nextpoint thing or whatever, or, in other words, what's attorney-client privilege for Mario. I'm sure there's some overlap, but I'm sure there's also a different set when it comes to Shanna and her attorney again, because, well, actually, having said that, my recollection is that when I was reading something just earlier tonight, when we were reading over the background stuff, my recollection is that both Mario and Shanna hired attorneys before they were arrested and charged, which is smart, but you could see why, because of the fact that it means that more information will be privileged, right? But that kind of gets into, again, what we've been discussing is like, is it really privileged? Because if they just hire an attorney, but there's nothing to talk about because they haven't been arrested or charged yet, then, but I can see the strategy there. But what I was gonna say is that, like, even regardless, because of the fact that they were arrested so different, like there's such a huge disparity in months there, what actually counts as attorney-client privilege will be different for Mario and his attorney versus what, what I mean? Even if they've got the same discovery that's gone back and forth, they're also going to have their own discovery that pertains only to each of them as individuals. So that's another interesting thing, right? There's going to be discovery about them talking to each other, but then there could be discovery of Shanna. I don't know what it is yet, but stuff that Mario wasn't involved in, right? And then of course her communications with her attorney, that's not attorney-client for him, right? Interesting.
Taint agent, because it wasn't a team, it was one agent.
Now I'm gonna ask you,
Wow.
To settle that issue, would you like another judge to hear that, or can you agree, or would you rather me deal with it through the metadata?
I think for that issue, based on what the deposition entailed with Ms. Butler, which this was outlined in the state's written motion, so to me, at least, it was not a surprise. She discovered an attorney-client communication while reviewing something, and realized it hadn't been properly detained and then we sent it. That line of communication, I think an independent magistrate could review. I never reviewed it, I don't know what it contains, but she could tell that judge in camera what it was without the state attorney's office present, and I'm fine with that.
Do you agree?
Yes, Judge.
Let me ask this. Have both defense teams seen that? Do you want it a separate hearing for each defendant, or do you want to have it concurrently?
When it comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings.
Yes, Judge.
Right. Like I said, right? Because again, that speaks to what I was just saying, where it's like, there's gonna be things that pertain to them together, and there's gonna be things that pertain to them each separately. So yeah, that he's like, if there's attorney-client privilege that deals with just them, I don't need to be involved. Yeah. Now, actually, hold on. Let me go back a second. Hold on. Let me go back a second.
Yeah,
I have another thought. Hold on.
comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings.
Yes, Judge.
That makes sense.
All right.
Yeah, maybe, Your Honor, for judicial economy, a lot of the same witnesses, it may be the same hearing for evidence, and then just like a Castigar hearing, I would be asked to be removed for a portion of the hearing.
Obviously, I'm not going to conduct them, so I'm just trying to be as detailed as I possibly can with the request that I'm asking the chief judge to do so that he can communicate and figure out who he would like to appoint. So what I'm asking, what would be required of the other judge, which is my understanding, which I'm going to repeat back, is that you all have a contested document on Mr. Fernandez's behalf, two contested documents. And then on Ms. Gardner's behalf, there is a communication that was not, that was communicated to law enforcement and
Two documents and one
communication.
message or text or something.
And I don't know exactly what the ATF analyst reviewed because
Right,
I obviously
yeah.
did not ask her that in an open deposition. So it would be a questioning for the ATF analyst exactly what she has reviewed.
All right.
And because I know that the iMessages were circulated amongst at least 4 law enforcement officers, I do not know yet if any of them reviewed them also before the team agent was able to go through. In full disclosure to the court, we may stumble upon someone that's reviewed more than the ATF analyst.
I'll also add too, as far as the privilege stuff goes, like I was just saying in terms of like them being separately but together, like they're two people, but they're both married, but they were estranged, but they're being tried together and all that, right? And they have their own set of attorneys. So they could, if they wanted to, I doubt they will. And it sounds like they're not going to do this, but they could, because they each have their own separate attorney-client privilege, in communications with their own set of attorneys. They could, if they wanted to, choose to waive that. It would be the defendant's choice. They could waive that. And then it doesn't mean you waive it for everybody. It means you waive it, like, in other words, to allow, if they wanted to be able to have the other set of attorneys read it, right? I don't think they're going to do that. I just wanted to point out that that is something that is an option, that defendants can waive attorney-client privilege. And in a situation like this, that might be something that could happen again, because if they're going with this like joint strategy. Now, again, I think it would take extenuating circumstances for that. I don't really know what the reason would be, but I just wanted to say that it's possible. So.
You didn't ask those questions during the depo?
Oh, that's work. I thought it was a lot longer.
Did she talk to anyone else?
Well, the problem is what she said is that she got the iMessages in an Excel spreadsheet that was emailed to her, and that there were detectives and other federal agents on that email. Obviously, she can't speak to whether or not those other people that
might be the thing that they were talking about being exported in an email. I think
on that email did, in fact,
that's
review the iMessages. We've not deposed those individuals. I don't believe I've gotten a copy of the email that was originally distributed to know who exactly was on that email.
I can get it. I can make those people available. I will say, they can check them. I don't have to take my word for it, but Ms. Butler was our analyst, so she was always the first and only person to receive and begin analyzing the evidence before everybody else did. So it's unlikely, but obviously I will provide those names and I'll get that email.
All right.
I will also say, I have a lot of thoughts here. So the other thing too, I was thinking, it's like, so my guess is that they hired their own attorneys after Henry was arrested, because that would make sense, right? That would be my guess. That would be reasonable, right? And for anyone who's thinking that could be like consciousness of guilt, like, oh, they hired an attorney before they arrested or charged, just for anyone, in case someone doesn't know, that cannot come in at trial. That cannot come in. That cannot come in. We can know that as the public, but that cannot come in at trial, and that should not be used. And in my mind, that to me does not, that's not a consciousness of guilt, but some people might think it is. I mean, if anything, it does point to them having a reason to hire an attorney. But having said that, anyone can hire an attorney at any time for any reason. You don't have to, like, anyone can just hire an attorney. You can just have an attorney on retainer. I mean, there's people that do that. There are people that just have attorneys on retainer in case they ever need one. Like, it's just a thing. So it doesn't, that's why I'm saying, but regardless, it can't be used here. So it's used against them.
Sooner rather than later. You want to come back next week?
For the,
Or, so based on my understanding in the party.
I know. Well, me too, Flash fan, me too. I feel like I don't really know enough about the facts of the case to really, but from what I understand, you know, yeah, it's tough. You know, I will say that this is maybe where there is a similarity to Kohberger in this way, that the best chance that these defendants in both cases have, from what we know so far, from what I know so far, right, is probably going to be something pre-trial. Like, for example, in Kohberger's case, contesting this whole thing about the way that DNA was got, you know, the search warrant stuff, right, with the DNA and the IgG and the trash. Like, in my view, that's one of the strongest issues they have, from what I understand so far, considering the property his parents lived on being private. And in this case, from what I know so far, it looks like the strongest thing they have is related to this attorney-client privilege and, you know, all that. Now, having said that, the fact that those matters are being contested in both those cases, that does not mean, like, okay, if you're a defense attorney, even if you know that, well, and Jose Baez is a great example of this with Casey Anthony, but this, you know, in other words, you don't only do those things pre-trial because you realize that the state has a strong case, right? Like, in other words, you know, with Casey Anthony, for example, the state has no case. The evidence is shit. There's no case. However, that doesn't mean that Jose Baez didn't try to fight all things along the way. Like, you know, it's going to be different with each case, whatever the issues are. Again, in Kohberger, I think their strongest issue has to do with that trash. And then here, the biggest issue so far that I can see is this breach of attorney-client privilege, right? And so with Casey Anthony, there was a whole other set of issues that you still fight those, right? It's not like by doing that, it means, you know, I'm just saying that because I can see some people being like, oh, they're only complaining about this thing because they think their client's going to lose. No, that's not it. They're going to fight everything. That's their job. But in Kohberger and in this case, from what I can see so far, I do kind of agree with what Flash Fan is saying here with like defenses. Like, I think the best defense is like, you know, pre-trial probably. Like that's what you really want to, you know, again, they would be doing it anyway, but it'll be tough, and it'll be interesting to see if it's going to be, you know, if there's really not that much of a defense, it could be, well, there's always some defense, right? But when in doubt, poke holes, right? Poke holes in the evidence. The problem is when there's really strong evidence, and the problem is if it was collected properly, right? You know, again, with Kohberger, it seems like the biggest issues are pertaining to the search warrants themselves, which is, you know, again, you get to that issue before you even get to the type of like, you know, what we see at trial, like, oh, did you, you know, wear gloves, and did you do, you know, did you collect things properly? Take care and read, for example, right? You know what I mean? But from what we can tell, it doesn't look like in Kohberger or in this case, there's any real issues with the way evidence was collected or with the crime scene. It seems like everything was done properly that we know of, right? But it doesn't mean that if they have, you know, if nothing else, they're going to try. That's their job. They're going to try to poke holes in that. They're going to try to show that things weren't done properly. It happens in every case. But the other question that I have to this is like, well, so what will it mean for their cases in chief? Well, they present a case in chief, right? Because if you're going with a poke hole strategy, if you're going with a strategy of like, you know, the state didn't meet their burden, you know, blah, blah, then typically it might sometimes be better to just not present a case, right? Because the state has the burden. And if you really think they didn't prove their case, then you might, an example of this. Now, I don't think this worked. Well, we know it didn't work, but an example of that is Lori Vallow. You don't see it very often, right? But when it came to the defense case in chief, there wasn't one. Her attorney said the state hasn't proved their case. And because of that, there's nothing for us to even do. Like he was trying to say, where we would have presented a case, right? Essentially, like we have a case in chief, but we don't even want to, we shouldn't even have to do it because we don't have to, because they didn't meet their burden. That was the strategy that they went with. Now, having said that, I could see with a more skilled attorney, I could see, like, say, Jose Baez, I could see a better defense attorney arguing that in a way where that actually could work and land with the jury, right? Where they could argue that in such a way that it's like, I agree, but it also depends on what the state has and everything. But in other words, my question is this, like, will they present a case in chief? Like, are they, and I don't even know that they've made that decision yet. It's probably too early. Especially when they're still going through fighting like right now where they're at is fighting over the death penalty motions. And all that is stuff that needs to be done first. Like the trial strategy is, they're reviewing discovery and stuff, but that's going to happen. That's going to be the last thing, especially in death penalty case, because the first thing is all this, right? The evidentiary issues, the search, in Koberger's case, search warrants, right? Here it's the attorney-client privilege. Then you have to fight over all the death penalty motions. That's your next priority as a defense attorney in a death penalty case. It's like after you get that initial stuff out of the way, then you're going to really think strategy. Because think of it this way, right? Your trial strategy would change depending on what happens with the earlier stuff, right? For example, if the death penalty is off the table, your trial strategy might be different than if it's still on the table. Just one example. So also because your trial strategy is going to depend on what the discovery is. And another example, right? If discovery is thrown out because of a search warrant problem, like for example in Koberger, or if certain discovery is thrown out because it broke attorney-client privilege, like what could happen here? We don't know yet. Could happen here, right? If certain discovery doesn't come in, that's another thing that would impact your trial strategy. So you want all that initial stuff to be done so that here's the discovery. We know what it is. This is what's coming in. This is what's not coming in. This is what the potential you got all that stuff out of the way, and then you would be as a defense team, right? You would be developing your trial strategy. It was not going to change that much for the state because they're the ones that brought the charges to begin with. They have to already have that theory in mind and whatever, right? But for the defense, they're going to develop their theory once they get all this stuff. They might have a general outline, but I would say that they really need to know what's coming in. And they need to go. And the other thing is, again, they just need to really focus their energy and time on this other stuff first, because best case scenario is it gets thrown out right off the bat and it doesn't even come to trial, right? That's the best case scenario, right? Yeah. What else was I going to say about that? So basically it'll be interesting to see what happens if they do end up putting on a case in chief and what it will be, right? Because really, usually that means you've got an affirmative defense, like in a self-defense case, or if there's an alibi, or an NGI type thing. Usually, it's an affirmative defense. Now, an outlier of that is Alex Murdaugh, because he had a case in chief, but there wasn't an affirmative defense. And the reason why is this: because initially the plan was to run an alibi defense, okay, and they, kind of like what I was saying. His defense team was already working on that. The alibi was he was at his mom's. Why? That's what came out of his mouth right off. He was at his mom's. That was his alibi. He left. He wasn't there. He was the first to sleep, and then he was at his mom's, right? And that was what they were going with, the alibi. And then what happened was that video, the Snapchat video, got discovered because that happened way late in the game because it took so long to crack Paul's passcode. So when that came out, they couldn't actually put on an affirmative out. Like they tried to, but it wasn't in the technical way where it actually counts, right? But that's kind of what they were still kind of going with, because that was already where they were at. So it was like an alibi defense, but like not an alibi defense. It was like pseudo alibi defense. That's why that one's kind of an outlier there, because they had a case in chief, but there was not really a solid affirmative defense to go along with it, like you have in other cases.
Ms. Gardner is going to supplement, correct?
Yes, Judge.
All right. How long do you need for that?
Judge, I'd ask for 2 weeks.
Okay. In the meantime, I will ask.
Can they bring what in front of the jury? Flash fan.
Judge,
What are you referring to?
Appoint an independent judge from this case When do you want to come back for your,
To set, all we need really is the 10 days for the transfer,
when did the depo occur?
Tuesday and Wednesday.
Okay, right. So it just depends. So here's the thing: attorney-client privilege. If it's attorney-client privilege, it can't come in. It can't. There's no question about it, right? Like it can't come in. Point blank. That's why the only thing is going to be, like, again, the state is saying that they're not planning on using all the stuff on the Nextpoint thing. They're saying they're not intending to use it. Okay, so it doesn't matter. Like it matters only in the sense that it matters in the sense that if they breach attorney-client privilege, well, okay, according to the defense, right? According to the defense, it matters if they breach attorney-client privilege because they breached attorney-client privilege. The state is like, well, it only matters if we're going to like use it and if it's prejudicial, right? That's why the state is really focusing on the prejudicial element as in prejudicial to the defense. And the defense is like not conceding that. They're like, it's privilege. They're going to use it. They saw it and all that, right? And again, like at this juncture, they're not even at this question because they're at the question of, was it privileged? Did they see it? And are they going to use it? Intend to use it. Now, the intending to use it part only matters if you get past the other thing of like, okay, for example, what I mean is this, like, if they don't intend to use it, you don't even have to ask really the other questions as much, right? You only really have to ask the other questions if it's something that they want to use. The example of that is that folder, the confidential conversations folder. That's the real heart of the matter, I think, because that is something that the state says they intend to use, right? Again, and they're saying we intend to use it and we can because it's not privileged, right? The defense is saying it was privileged because it had that label, confidential conversations. We don't know the contents of that, and that's still up in the air, right? And that's going to be the whole point of contention, because what's going to happen is someone's going to review that and they might see that it's just evidence, which is what the state contends. They might say, yeah, it's not privilege. In that case, if they look through it and the team is like, that's privilege, that's attorney-client privilege, it can't come in. There's just no question. It can't come in, and no one should be seeing that except for the attorney and the client and the taint team. And so, like, for example, can Baez get up in front? I see what you're saying. In front of the jury opening, say that my client's rights are violated by the state. No, I mean, he can't if it was found that they weren't violent. Like, it depends on what it is. Like, okay. I'll give an example. Okay. I'll give an example. In Delphi. That came out, right? That came out. Like that was one of their whole things was that Richard Allen's rights were violated by the state, and all the stuff he was subjected to, right? Like essentially almost akin to torture, right? And that resulted in the false confessions and whatnot. They definitely contended his rights were violated by the state. I agree with that. The reason that could come in, though, and this is a great question from you, Flash Fan. I'm glad you asked this question. The reason that could come, that they could do that, is only because the evidence that the state wanted to use that evidence at trial, and it came in. Like what I mean by that is the jail, the false confessions, right? Or in the state's mind, the confessions, because of the fact that those confessions that they were going to come in, the state wanted to use them. And there's a lot of examples. Like basically everything in that entire case that came in, the state wanted to use it, but all of it could also be seen as violations of, their clients' rights and constitutional rights and all that. I don't know, there was much that came in that doesn't count as that. So, but my point is that if the state doesn't want to use it, like if it doesn't come in, if the evidence itself, if whatever it is that whatever is the basis of the constitutional, rights being violated, whatever the basis of that is, if that thing isn't coming in at trial, A, because just no one wants to use it, or B, because it was, there were pretrial motions on it, right? Motions in limine, or, whatever the case is, it's not coming in, then you can't make that argument. You can only say that. You can remember, anything that comes in opening statements has to be based on the evidence that will be presented at trial. That right there simplifies it. That's the easiest way to understand it. They can only make opening statements based on what they expect the evidence to show at trial. So if something's not coming in, And that, but let's say there was something that could be a violation or maybe whatever. If it's not coming in at trial, they can't comment on it. Now, closing arguments, they have a little more leeway, right? But they still can't, if it didn't come in at trial, they can't. And that's where with Delphi, because the state knew that the defense was going to say that it was but they wanted to use it and it came in. So that was the whole thing. But that's kind of an outlier, I feel like, in that case with that whole thing. But hopefully, did that make sense, Flash Fan? It was a really good question. But it doesn't mean, like, there could be other things, right, going along here, because this trial is not until October of 2025. There could be something else that the defense views as like a constitutional violation. There could be something that does come in that the state's like, we're going to use it anyway. And then you can argue, you can, deal with that. It could happen. But at this point, yeah, hopefully that makes sense. Okay, good. Awesome. Yeah. Motion to eliminate. Yeah.
There really wouldn't be a need for me to see you all. The appointment can be made, and then the scheduling would be with the other judge. I can put this on for status.
Yes, ma'am.
Yes, Judge.
So you need 2 weeks. You need time to get the transcript, which it looks like by my count.
And I saw this on the docket. A lot of the stuff that's in the docket that we probably won't go over is stuff. Well, I see. Okay, let me correct that statement. You can see it in the docket, but there's no actual attachment to view. And it's because it's this type of stuff where they're getting, transcripts of in-camera stuff or transcripts of depositions and stuff like that. Sorry. But my point is, like, there's a lot of that going back and forth and wanting to get transcripts. There's also a good bit about the grand jury getting transcripts for that. And like, though that does have an attachment, but it's just like them asking to get the transcript. Obviously, it's not the actual transcript. There's no way that we will ever see that.
It would be ready, it would be February 29th. If I count 10 business days, if you ordered it.
We did, and Ms. Butler chose to read. I don't know how that delays or not.
Okay. So would you all be prepared to supplement without the transcript or no?
Judge, I believe we would, based on my notes from the deposition.
Okay. What does your scheduling look like in early March, so I know when to bring you back for status? What I'm saying is you would appear in front of the appointed judge, okay, to review. I'm assuming that judge will need time in order to process and do an order. I can come back
March 4th.
March 4th, anytime that week, or the week of March 11th, you can let me know where you are with the other judge, if you want me to do that, or I was just gonna set this for status at this point.
March 4th for a control date to see where we are with the other judge.
So they're just deciding on the scheduling for upcoming
Fine
hearings.
with the defense teams, Your Honor.
Yes, Judge.
Okay.
Can we do March 5th? The co-defendant is such a parent not on board.
I'll reset his date. You want the 4th?
Yes, ma'am.
Yeah, Flashman, I know it's in the Discord. I'm just asking if you know the date, because there's a reason I'm asking that. If you just could tell me the date.
I just set that as a status on the Tenon case, knowing that these cases would dictate a court date for him, okay? So we, on both Mr. Fernandez and Ms. Gardner, we will come back on March 4th, 9 a.m. status hearing.
Thank you, Flashman.
Clarification. Mr. Carodi is requesting the names for the email with the spreadsheet, because we're in this situation. How do you want to receive that? I'm not going to ask that they forward me that email because they're contesting that it has privileged communication on it. So
I would imagine like a PDF or a printout and scan of the email itself that just shows the attachment would
She
not.
asked me, she doesn't want to get it and give it to me.
Right.
How do you want to get it?
Ms. Butler can just forward it to me.
Okay, I'll have her do that.
Judge, I don't know that the email itself would be privileged. It's the attachment that's privileged. That was just the point I was making.
How do you know it's in it? I thought you hadn't seen it.
I haven't, but the way it was described to me was it was just forwarding an Excel spreadsheet with the iMessages in the Excel spreadsheet.
If you'll have,
That's fine.
the agent or directly. Okay.
And then lastly, Your Honor, the motion for our mitigation specialist to go to the jail, we're working directly with the general counsel from the city and the chief of the jail to resolve this issue. And I believe that we're going to be able to self-resolve it.
You are, okay,
I think so.
all right. Anything else we need to take up?
Thank you.
No, Your Honor.
So, obviously, when the chief judge makes his appointment, that will be communicated to the parties. I will see you all back on March 4th, finding in for status of the cases. Thank you all very much.
Thank you, Your Honor. We've excused. Thank you.
March 4th. All right. So what she just said is March 4th, they're going to come back for a status hearing. I don't know. Let me see if that one is televised. Because thank you for that, Flash. Because here's I'm making an upcoming plan. Let me just see real quick. Let's see here. Let me look at this. Don't play it. No, don't play it. Okay. So let me see something real quick. I need to just look at this date, March 25th. Okay, so she's saying they were just saying a status hearing on March 4th. I'll figure it out by looking at the docket because it looks like there is a hearing on March 25th. So I'm wondering if that got pushed out, which is entirely possible. So here's why I'm mentioning that, because the next thing that will happen in terms of like what's going on legally here, let me pull this up and show you guys. So, well, okay, because here's the plan for the next one. The next one, what we're going to do is we're going to watch the body cam. We'll probably do that first. I'm really excited. It should have been streamed. Okay, maybe I just missed it. I don't know. I'm wondering if it just got pushed back. But here, let me show you guys. So the next thing we'll watch on the next stream, we'll start with the body cam. And then, let me reshare. Okay, because going again in chronological order. This is March 1st. The reason I'm wondering if that March 4th hearing got pushed out is because this is March 1st. And so that means this is a 24-page. This is the big one. This is the big one. I'm going to read the title here. Defendant Shanna Lee Gardner's supplemental pleading to motion to disqualify office of the state attorney and motion to dismiss the indictment for violation of the Sixth Amendment. There it is. Y'all, I called it. Now it's coming in. Finally, thank you, Mr. Baez. Mr. Baez is like, yeah, I'll go there. Sixth Amendment. Yep. Sixth Amendment right to counsel, prosecutorial misconduct, and outrageous government conduct. And it's in all caps. I just got goosebumps. This is a lot coming from him because he's very mild-mannered when it comes to stuff. I mean, even in Casey Anthony's trial I would say there's outrageous government conduct in that trial. He never says anything close. This is like insane. Like, I understand what this means coming from him because I know what he was dealing with in Casey Anthony's trial, and that he was very much understating anything and very polite. And yeah, anyway, so this is a lot. This is March 1st. I'm wondering if that March 4th hearing got pushed back because they needed to go through all this. And it says supplemental. So that makes sense, right? Like if you file this supplemental, yeah, you're going to have to push back the time. So I'll see that on the docket. So we'll do the body cam and then we'll do this. And then I believe, let me go back to this. The May 15th is the bond hearing. So that means that what'll happen is the hearing that I believe is the next hearing will be the hearing dealing with all this. So my thought is it'll be this, and then it'll be the hearing on March, what did I say? 24th or something. They moved, if they moved it. And then, yeah, anyway, we'll go through it. So it's good to know. That's why I was asking the date, because there's a lot of things that happen in March and April that we'll go through before we get to the bond hearing, I'm thinking. Okay, March 7th, they meet with the special master. Right, that's why. Yep. That all makes sense, because this hearing that we just watched was February 16th. It makes sense that other things happen, that things get delayed all the time, right? It would make sense that there were things that happened. And so March 7th, they meet with the special master. And then, or the special judge, they use both terms, I think, in the docket. So, And maybe they have both a special master. I didn't actually delve into if they're one and the same person or not, because I don't, it doesn't really matter that much. But yeah. So this is the next. So we'll do. That's gonna be. Next one's gonna be awesome. We're gonna have the body cam of the arrest. We're gonna have this. Incredible. I can't wait. I'm not going to read it ahead of time because I want to go through it in real time. And all I read is the title, but the title already is like, wow. And then we'll have the hearing, and the next hearing is going to be on all this, right? It's going to be argument on all this stuff. That's going to be exciting. And then again, tomorrow, there's going to be the next Casey Anthony episode. It's going to be also really exciting. I'm sure I can find it, but you're welcome to put it in the Discord. You can watch that as well. I know I have seen Shanna's body cam arrest, and I remember thinking it was interesting. I don't know. Sometimes there's some body cam arrests that are not all that interesting. Hers was interesting. It just sort of depends, like if they say anything, and if they do anything. So, but if you think it's interesting, then we can definitely watch that as well. If it's just like he gets arrested and then that's it, I don't know. But but she definitely says some interesting things that I don't remember what she says, but we will see it. I just remember thinking it was interesting. So, so coolio. So that'll be it for this one, because I need to finish up some stuff to get ready for, oh, he does talk. All right, then we'll watch it. Hopefully they read him his rights. But yeah, I need to get some stuff finished up for the, Casey Anthony stuff for tomorrow. So yeah, but yeah, that's it for this one. I will say, I would love it. This is just me thinking out loud, like wishful thinking. I didn't think of this at the time because I was so flabbergasted that UNCIVIL Law was there. But I wish I'd thought of this while he was still there before he went to sleep, to say, hey, did you know I'm covering Casey Anthony? Because I think I would love to have, I feel like everyone should be watching that trial. And I feel like people don't know, like there's people who I know would be like, this is a really interesting trial, and this is a really good case. Like, this is a really, like, in the sense that like, there's a lot of craziness, right? Like, it's just no one watches it, so they don't know. And I feel like, especially attorneys, especially other attorneys, they don't know what they're missing. That's what I guess I'm trying to say. But if they were to watch even 5 seconds of it, they'd be like, holy shit, how has no one covered this? until me, right? Because I feel like Kurt would be someone who would be like, holy shit, what? And he would want to watch it, right? I mean, and I would love to have him there to weigh in on things, of course, right? Obviously. Because then it's not just me that's like freaking out about what's going on by the state, right? Because sometimes it's hard to appreciate just the level of fuckery, right? Unless you've watched a lot of trials and a lot of law tube and studied stuff, or whatever, or if you are an attorney, right? It's hard to really appreciate the gravity of this. And especially because so many people are just so, they can't get it out of their minds that Casey did it, and there's just no hope. But attorneys are able to do that because that's part of their job, and they actually can look at things objectively. And I'm just so grateful. Also, I'll just say to that, and I'm just so grateful for LawTube and for trials, because I've said it before, I'll say it again. I think trials make us better people because you learn to be objective. I was just saying this the other day to somebody, right? I was saying, even if you're someone who considered yourself objective and unbiased, I would say that I probably considered myself into, like that, and just as a general person. But I will say that however much of that I was naturally, by delving into trials and getting more and more, learning more and more about the law and all that, you learn that you weren't nearly as much as you thought, and that you can do better. Like, it really teaches you that. It's a skill set that's so important and very few people really have. I love that it has taught me to really scrutinize things. And again, really come at things objectively. And that's what, and that this Casey Anthony trial is a great example of where there's some people who just can't let themselves go there. And it's like, it doesn't matter what you show them. It's like flat earthers. It doesn't matter what you show them. Casey did it. And I appreciate that, like, for me and for anyone else who's been watching that trial with us, right? That for the people who were like, I can do it. I can go there and I can come back and be objective and watch this. And then you see it for what it really is. It's healthy for the brain. Well, that's the goal. That's the goal. For sure, so I just appreciate, I feel like it's made me a better person. And I think it's really, that's one of the things I love about it. And I, it's a great challenge, right? To really be able to stay objective and unbiased. It really is. And there's not a lot of things that really can teach you can challenge you on that and really teach you that you can do better. I think the law and following, really, if you really want to follow trials and understand them and get the most out of them and do it correctly, like it will teach you that. And I just love it. And I don't know that anything else can do such a good job, with that. So anyway, but okay. I know I said bye before it was a fake one. Now's the real one. Y'all are awesome. Thanks for being here so much, guys. School Crew for life. Love y'all. And I will see you guys on the next one.